trying to love straight to send or into your approach or some other bench because it's a content of the previous bench. No, nothing. Oh, it doesn't say that.
This is a matter arising after my lords have taken over as the Chief Justice.
This is a medical admission matter.
Then how do you say it is a content before this court? So his lordship would have to take up the matter. It must be by the previous bench.
Yes, yes.
So it on administrative side, it need to be allotted whether to this court or to some other bench.
They have moved Millard already. They moved 5 Millard, but
I'll put up the administrative
not
side.
yes.
Yes.
You should have said that it is required to be dealt with on administrative side, right? Brother is telling me you should say, Mr. Officer of the court. Yes.
Yes.
No duty to be fair to the court all times.
Yes, okay.
Yes.
Don't it should like
A batch of 3 writ appeals
Ah.
where there was a direction for the government to file a status report in respect of disciplinary inquiry
Ah.
initiated against the officer concerned collector. But the complaint was that the complainant himself was not examined. Then the learned AG undertook that.
what is the urgency?
The urgency is the inquiry is not progressing at all. Then alternatively, I have also sought for an inquiry by CBI.
What?
But they were direction to the status report that is not been submitted since last 2 years. And because of the change of benches, was one bench recused and then we had a problem. The other day I had made a mention. When his lordship
Which
was-
bench recused? What happened? I mean, this appears to be something. It's pending for 2 years, right, Mr.? All of a sudden, after 2 years, you think that there is
The
urgent.
difficulty is twofold, Otherwise, I would not be able to mention.
Ah.
The difficulty is that instead of initiating disciplinary proceedings, that officer is now promoted. Nothing has been done. That one thing.
What is your claim? I mean, for promotion.
No,
Ah.
my claim is that I am dispossessed by virtue of the orders of this officer. This officer has admitted
Dispossessed from property.
my property,
Ah.
urban property, city.
Ah.
Officer has adjudicated.
So you
I have no
want
right.
this thing, you want restoration of your position.
No, for that I have initiated a proceeding because
Ah.
Rit Court said
Ah.
the honorable single judge directed that disciplinary inquiry be conducted and then take action against him, take criminal action against the persons who are involved. Now criminal action is not taken. Then person involved in a writ appeal, this honorable court directed them to file the status report.
So
every
for what purpose you want final
But I
hearing?
want a status, but I want a status report in the CBI inquiry because police has not done any inquiry. There is an application pending before this court. Otherwise, I have also sought for
10th August. You should know when to mention.
the lordships.
Please go there, go there. Come this side, left hand side. Come here.
The lordships kindly.
One.
I'm sorry.
Come. You please, senior counsel, please assist and advise him when to make a mention for 11 petition. You listen to him, senior counsel. He will tell you something.
Please.
You will learn something. Please tell him. Yes.
I'm already.
This is not the different combination, right?
Lordship,
The lordships
Yeah.
have fixed it for 10th,
10th.
not attending court.
17th.
8th or 11th.
Huh?
No, 17th. 7th is a Friday, Mr. Prabhakar. It will be-
9th, correct, on 9th.
No, can we take it up on 17th?
It was 10th and.
All right.
Fine, 17th.
Lordship's permission, my lord. This
You want to mention urgency matter,
Lordship,
fresh matter, fresh.
writ appeal, my lord. It is in
When did
admission,
you file?
admissions
When did you file the writ appeal?
in the month of March, my lord.
Then?
Lordship, it is the
Since, no, madam, you want to
admission
tell us
matter, my lord. Is
whether since March it has not been listed.
It has not been listed even once.
listed, my lord. Notice has been ordered.
Ah.
After that, it is not listed,
No
my
date
lord.
is given.
Lordship,
No date is, system is not showing any date.
date is given, my lord. On the date, it is not listed.
That's why I'm asking, what is the date the system is showing today?
Lordship,
Is the system showing any date?
no,
No date.
not.
What is the urgency matter?
Urgency is the freedom fighter, my lord. He is the senior citizen above 90 years, my lord. Writ appeal has been filed.
Writ appeal.
All right, 9th August, man.
Obliged.
Can be permitted to move a large funds. The urgency in this matter is the writ petitioner is a lessee of a secured asset, and they have been issued with a vacation notice, and it's dated on 8th of August. It's a fresh matter, it was numbered yesterday, it's not listed today.
It will come.
Monday.
It will come on
Monday.
Numbered yesterday after 1:30.
Aha,
It
so-
will come.
Anything,
Which is numbered after 1:30. Either in this court or other court, 1:30 is the cutoff time. So automatically matter will come on Monday.
There was an urgency, Your Lordship.
You need not mention, we are ensuring that anything which is numbered before 1:30 comes on the next day.
if it is not mentioned on Monday, please mention. If your case doesn't come up on Monday, then tell
Then
us.
we can mention with.
We'll take it up on Monday itself if it is not listed. We want to test the system, Mr. How it works.
What is the number? Tell us the number. We will check up why it has not come.
It was numbered yesterday, Your Lordship.
Tell me that number.
WB 2014 of 2023.
21
21014 of 2023, Your Lordship.
210
14.
of 2023.
Yes, sir.
We'll also check. Not required. 1:30. If it is numbered after 1:30, it would not have come.
It would have been numbered after 140.
Then
Was that-
it will come up.
That's why I mentioned, it's
No,
not.
no, it will come up on Monday. Don't worry. If it anything numbered before 1:30 will come next day.
We want to test the system.
Ah.
If it doesn't come up, then you tell us. We will take it up on Monday, right? We told you twice. Enough.
Like,
Yes.
Medical University Council, we can ask him to be one.
Which?
Mr. Prabhakar, we have given some medical lunch
Matters, right? 1 o'clock, please obtain copies and be here. Seek instructions in the meanwhile. Appear what?
Those matters, medical matters, he has been instructed to.
Whatever seek, the purpose is to tell you to utilize this time of 2.5 hours to seek instruction. Don't say, I want time to seek instructions at 1 o'clock. Purpose is only that. Yes.
Yes.
Ah.
All the list.
Who appears doesn't matter, but you should seek instructions. In the meanwhile, what is it? Yes.
May I please, Your Lord, to represent Sections Council.
Ah.
But before, my learned senior, my Lord, this makes a mention, I'm on caveat before the learned senior, but the matter is already reserved by the trial court. Main OP itself.
That I will address that in illegal order.
Or on first itself.
The simple solution to this is we direct the trial court to pronounce the judgment within 3 weeks.
Yes,
Brother, what happened, my lord?
in fact, even
If
my,
you want to argue, then supply copy.
Yes, it's already supplied.
it is applied last night at 8
Last
PM.
night.
Last night at 8 PM.
But you want time.
Yes,
1 minute I will take, not only legal order, my lord, page 6 I will see. Just your lord's.
No, Mr. Your case is, we will tell you. Your case is that you had filed an application under section 14 of Arbitration and Conciliation Act.
They have.
They have filed the proceeding challenging the proceeding initiated before the arbitrator on the grounds under section 14. The commercial court, the trial court, your case is that even though had heard arguments on merits, but instead of passing argument on merits has granted stay. Right, so-
6 months.
So granted stay. So now this is the point. If you read page 6, please read.
Page 6, my lord, heard the land council on both sides and the matter is reserved for orders. In view of the submissions made by the land council for whether the land arbiter is going to pass an award, the category 1 is main case, category 2 is interim case. The category 3 without where from, in none of the procedures it is applied with great respect. And we
No,
don't pass an
goodness.
order.
That's why in anticipation that you have a very good case on merits, he has appeared. So he wants time.
6 months, 6 months.
So what do you want us to do today?
The only thing is this order, my lord, pending reserving the orders on the interlocutory application.
You want when the arguments were heard?
8/3/2023, my lord. 6 months is over. I back at order.
No, not 6 months over. 6 months will be over on 8th March 2023.
8th March.
Please,
And
be fair.
I'm against this, my lord, your lord.
No, no,
I'm
on
sorry.
facts you should be
I'm
clear.
sorry.
Today is 4th August, right?
But on, as against this, website when the subsequent cases are posted,
So yes, your submissions are what? Number 1. 6 months have passed. Number 2.
6 months is going
Ah.
on 8th.
So 6 months have passed. The judgment has not been delivered for
Not
submission.
delivered. I
Second.
pay for your lord's payment.
Submission, Mr.
Submission is.
You are here to assist.
Yes.
Ah.
That page,
If in your this thing, then you sit down, we will see 84, 85, 89, 45.
when the.
You are here to tell us there's nothing great about it. We have told you, I have done nothing to argue according to us, but still, for your satisfaction, you will say, I have not been heard, so we are hearing. We told you, what are the facts? If it is incorrect, tell us that, no, these are not the facts of my case.
Only one fact I will tell you, your lord's.
Ah.
The order which I have, docket order I have read, your lord's, before your lords. In the website, Milan, page 84, it is stated that councils are both sides present, IA number 43 is pending, it request Kala, page 84. And later on, Milan, generally the court writes that whenever the case is next posted, urgent orders are not ready, posted. But as the IA number 43 is not at all argued, all other further docket proceedings, I don't want.
What is IA 42 of
IA
80?
The orders are reserved on 8.3. This shows that the arguments are.
No. So, all right. So there is a discrepancy in both the orders. Got it. One which has been passed by learned single judge, the commercial code, the one on which has been mentioned on the web portal. So what is your submission? This order impugned has been forced by someone?
My only thing is that having not been there, it's the interlocutory nature only. The court would have. Because nobody's case that the award is going to be passed. Even the respondents in their petition, they have clearly stated that it is posted for cross-examination. It will take some time.
When proceedings are, just a minute, when our proceedings are fixed for before the arbitrator?
Yes.
We are deciding it today itself.
3 weeks,
No
your lords.
time.
3 weeks, your lords, directed, as suggested by your lords. 3 weeks without fail, because.
Without fail, of course.
Only that my submission, because.
That's it. That's the simplest solution. It should not have taken more than a minute, this case. So,
Only thing of it is my duty, madam.
please, no, correct.
Your lords being chief justice, as
No.
supervised power over the.
Yes.
But I wanted to know that.
Yes. What else? What else?
3 weeks, your lords, my direct to pronounce the order.
Order. Correct.
That's not difficult. In fact, learned judge said within 2 weeks I may be able to.
No.
It is not IA, but may I submit one thing? It is not the IA. Main OP itself, the learned judge is deciding now. It is main, madam, kindly see the order. No, may I only.
Don't, mister.
No, I am not saying. Not IA.
Don't defend the judge. You are not appearing for him.
No, I am not.
He is our judicial officer. He has brought it to our notice. We will deal with him. You are appearing for a party.
No, I am not on that flat.
No. You are appearing for a person, right? A party to the proceeding, not for the judge.
Yes, not the judge. I am not for a moment defending the
That
judge.
substantiates your
No, I am not.
mention that.
But may I submit only one thing, Virat?
There is nothing to Mister. We don't know why you should oppose this prayer that give a direction to the commercial judge to deliver the judgment within 3 weeks. I don't know.
No, I am not opposing.
Then what is to, he has understood after putting in some effort, he has got it. It's his petition. You want to oppose?
No,
This
I
is
am
your
not.
submission.
No, I am not
That this court cannot direct the commercial court to deliver judgment in 3 months.
No,
3 weeks. Number 2, what else?
That's what. Rajpati. Now, the CRP that is filed is inaction in disposal of IA, which was reserved on 8th March. My submission is to your lordship, the CRP itself, the COP, main COP itself is reserved for orders. Now the CRP before my lords is.
No, main COP was reserved on 8th of March.
It is IA that is reserved for orders. But what is not part of the record that I may bring to your lordship's notice, the learned judge's daughter is shot dead in USA. Therefore, it could not be pronounced. And therefore.
How do you know? He told you, judge.
No, that is reported in newspaper. His daughter is shot dead in a gunshot.
No, so that is the most tragic
Yes, most
event
tragic.
can happen with anybody. No. Learned judge called you and told you that this has happened, therefore I am not delivering judgment.
Learned judge said, instead of IA, I will decide the OP itself. You and impose cost. We argued.
His case is his case is that the arguments on merits have been heard. The judgment should have been pronounced. Instead of pronouncing the judgment, he has granted stay. That's the submission. Are you disputing that arguments on merits have not been heard?
Arguments in IA were heard, not in COP on that day. It is only IA that was heard. Now COP itself is resolved by submission.
Mr. Venkateswaran, on that date is not heard. What he submission is pending the hearing, this order was passed. Therefore, today what we are asking is if COP arguments are heard, tell us the date when it was heard.
COP argument heard. Instead of IA,
Don't. First of all, you are speaking into the mic. So therefore, there is no need to shout. Or you switch it off and shout. Huh? There's nothing to shout, right? We are not hanging you here right away so that you will cry that I should not be hanged.
Tell us the date when the COP arguments were heard.
Arguments are filed in the next COP.
No, when arguments have been heard.
On 3rd August, day before yesterday.
3rd August, the final arguments have been heard.
That's my direction to
Correct.
pronounce the final
Simple,
argument.
right? So, yes. So what opposition, Mister? Now you are up. Then why you should not have said that final arguments have been heard on 3rd of August? Please direct the commercial court to decide, deliver the judgment. Not bringing. He said, you are shouting and he is telling us that 3rd August arguments have been heard. You are telling that IA has been heard. All right, enough. If you speak a sentence, we will impose cost. In this petition under Article 227 of the Constitution of India, for 227 petition also we require half an hour. See, this reflects on the quality of assistance being given to us by you. People, you means members of the bar. If we take half an hour to decide 227, you should reflect upon yourself. It's all we are telling is that it's a valuable time. The time of this court is valuable. Think about it. This could have been cut short in no time. Got it, mister? Huh? You didn't say that. Saying anything, shouting, did everything. Said everything. That after filing of COP, 3rd August, final arguments have been heard. Your Lordship may dispose of within such time limit as your Lordship deems reasonable. We would have decided. Simple. You are saying, I want time. Before he speaks, I want time, you said first. Yes, correct. You realize this. It would have been done in a much faster manner. Barbie presence, no submission now. We are wasting time and energy by telling you. If you don't understand, we will not speak anything. In this petition under Article 227 of the Constitution of India, the petitioner has assailed
Most of the jobs are being secured. Percent of the Americans or Indians. Yes, yes, sir.
My
Jews, they are very person. Some police friends sharing the this is the word.
Yes. My apologies, Your Lordship.
No, no.
Before Your Lordship, no, regarding this, Your Lordship, today morning I observed that by clerical omission, the reply affidavit papers are not made part of writ appeal by clerical omission. I seek all this, Your Lordship. I filed today.
File it. What are you filing?
The reply affidavit which was part of record, I omitted, it's omitted clerical omission, My Lordship. But anytime next week in morning.
All right, learned counsel for the
Sorry for-
appellant undertakes to file what reply affidavit
Filed in the writ petition.
filed in the writ petition in this writ appeal during the course of the day.
Lordship, next.
What, Mr. Today is the date you seek and
No, my Lordship.
all these today's cases are listed on Monday. What happens? 160 cases.
I'm sorry.
Huh?
I'll file. With the Lordship's permission.
Yes,
Lordships, we have challenged
this similar petition had come. Huh? 9th
Lordships,
August.
the issue, Your Lordships, is the
We
counseling.
know the issue.
My humble submission, Lordships. The counseling is beginning today,
Huh?
and today, tomorrow, and day after.
Huh?
The
There
seat
is an
matrix
interim
is
order in that case. Where is that? Instead of arguing, you should have
Your
told, no,
Lordship,
that's
the
simpler.
the issue, Your Lordships, is they have published the seat matrix yesterday, Your Lordships, in which they are not.
102. You have annexed in your favor, not disclosing what to do. He is telling.
Lordships, new facts have come up yesterday, Your Lordships. I'm making a submission with respect to the new notification that has been published by the university, Your Lordships.
What do you say, 102, that this thing you have registered yourself for admission?
Yes, Your Lordships.
So they have been, what is should we read it out for you? What is the order passed at 102?
Lordships, the order indeed says that they can proceed for the admission, Your Lordships.
Your documents, Mr. It's not our case. We are not seeking admission to MBBS course. So you have to answer the query of the court, right? First read how this direction will not suffice, then tell us.
Your Lordships, the problem is, Your Lordships, yesterday,
What you have still not read it.
my apologies. The respondent university shall entertain the application of the petitioner for registration for admission of the petitioner will be subject to the further orders to be passed in this writ petition. Lordships.
You have applied,
Yes, Your Lordships.
registered,
Yes, Your Lordships.
registered or not?
For me to go ahead and opt for counseling, Your Lordships, I am not being permitted beyond the seat matrix in which I am being permitted. Only those 20 colleges which have been established prior to 2014, in those I am able to put forward my options. But with respect to the remaining 38 colleges which have been established subsequent to 2014, in those colleges I am not able to. That is my grievance, Your Lordships.
How many 14 colleges you are allowed to opt?
Your Lordships, total colleges are about 58, out of which 20 colleges are the ones which have been established prior to 2014, which is prior to bifurcation. Now, the remaining 38 colleges have been established after bifurcation. Now, if I have to make my application or submit my choices with respect to all 58 colleges, I am being permitted to.
Got it.
Okay.
Yes. What do you say? No, correct. So we will take it up on 9th of August, but in the meanwhile, permit him to indicate options in respect of all the remaining 38 colleges also. It will be in any case subject to result, right? The effect is not that he is granted admission. See, Mr. That day we told you, our prima facie impression, what subject to you people argue is that reservation can be provided on the basis of a domicile. The only issue on that day also we repeated, you heard it only to the extent. This is 100%.
Not the
We don't know. That's what they've said. In the petition, if they are making a incorrect factual submission, tell us how much is the reservation for on the basis of domicile.
Yes, prior to 2014, Lord.
31st July 23, Mr. What is this thing? 31st July 23, notification.
Yes, sir. But July notification says, Lord, the colleges which are established after bifurcation, where the unreserved seats of 15% will not available to where the Andhra Pradesh candidates. Not Telangana people, Andhra Pradesh candidates. Where prior to our bifurcation, 15% of seats in Telangana are reserved for unreserved seats. In unreserved seats, candidates from Telangana as well as Andhra, that Nagarjuna University, the Tirupati University are eligible for making applications. After bifurcation, Telangana government established.
Other matters are coming up on 9th August, right? We are not deciding this today.
Yes, Lord.
We are asking is in the meanwhile, what is the last date of it submitting options, Mr.
The counseling is scheduled today, tomorrow, and day after, Lordships. Day after Sunday is the last date, Your Lordships.
Let them indicate this thing, right?
I just
Options.
Lord, we will, Lordship, kindly see, Lordship, put it on 9th, we will not really make allotment orders. Team Lord 9th. We will not make allotment orders. Allotting seats.
My grievance still sustains, Your Lordships. Once the counseling concludes, I can't opt for the colleges. Even if they don't go ahead and give me allotment or not allotment, I can't opt. And others would have opted and seats would have gotten closed.
Even they cannot say that it is not open. They have to let us know. We can't want that they will not the seats. They cannot allot. They cannot allot everything. Yeah, but maybe we should indicate the option. What will not post?
What happens if they are permitted to indicate their options only, right?
Because it is.
You are not allotting seats in any case. So at least, permit them to this thing, indicate their option.
Because they are not entitled for making option, but
That is the issue which is to be decided, right? Like, see, without deciding this petition, without you filing a counter, you are saying not entitled. That question has to be decided by a division bench of this court, subject to orders of Honorable Supreme Court. You can't say that I will not do it because are you not bound by orders of this court?
I'm bound by the orders.
Fine. Then that issue, we thought, Mr. You are such an experienced person, you know that this issue needs adjudication, correct? Pending adjudication, we are asking you what will happen if they are permitted to indicate the option. We are not directing their admission. We are not directing their allotment. We are not directing their admission. You yourself are saying that we will not allot seats. So till 9th of August, till you respond and everybody else responds, allow them to indicate the option. Supposing if he doesn't get admission on its own, then we will, at his instance, we will not adjudicate this petition. He will withdraw it. Correct? Supposing on the basis of inter se merit, you find that he is outside the zone of consideration. What happens to his challenge? Supposing if he is a meritorious person, then what relief would be granted to him in this petition? So direction to everyone to create one additional seat for him. We don't want that. Right?
The only option is the only option will be to stay the indirectly.
Yes. So which is that judgment? Domicile. Learned counsel for the petitioner. in this writ petition, learned counsel for the petitioner has assailed the validity of the order dated 3/7/2023 by which uh, a reservation has been prescribed on the basis of domicile.
Yes, Your Honor.
Reservation has been prescribed on the basis of domicile in MBBS and
Based on presidential order. Presidential order.
Domicile is what is considered under presidential order, Your Lordships. On the
Geo-
basis of domicile is what
On the basis
presidential
of
order.
presidential order.
which presidential order, Mr.?
2018 GOMS number 124.
No, he has challenged 3/7/2023, correct?
Yes, Your Lordships.
Then that's what we are saying, Mr. He has not challenged 3/7/23.
No, Lordship says domicile, not on the basis of domicile, but in the basis of presidential order, we had 15% of seats for the
Acha.
state.
What have you written, madam? Domicile in view of presidential order dated,
1973 Act.
which is presidential order?
1974, Your Lordships.
What is the name, Mr.?
The order was
No, Mr. One thing we want to understand. What is the extent of reservation which has been prescribed? He says 50%, you say 100%.
out of 100%, Your Lordships,
Ah.
85% is for the local candidates. 15% is open for the non-local candidates, such as unreserved category. Now, the issue, Your Lordships, is as per Section 95 of AP Reorganization Act, for the period of 10 years, whatever has
No,
been.
not issue. We are trying to understand the nature of provision. He said only 50%, not 85%.
We are not worried about the 85%. The 15% is not being permitted to us. That is our problem. We are not being permitted in 15% also.
15%. 15% unreserved seats in which locals as well as non-locals will compete.
So then that
But
is grievance.
those colleges which are
Grievance is different, right? I got it.
So 15% will only be improved in that.
He is not challenging 85%. So, Mr. As we understand, that reservation is provided for 85% local candidates, correct? 15% for non-locals, local and non-local, correct? He is not aggrieved by 85% reservation prescribed to locals.
No.
His case is that in respect of remaining 15%, which provides for reservation for local and non-local candidate, you are not permitting to appear in the counseling process in respect of colleges which have been established after
2014.
after bifurcation. That's the grievance.
Yes, Your Lordships. Greatly obliged. That is it.
Mark. So we want to understand. You will respond it. We have learned, mark the present.
Pledge, Lord.
Not with that date. That's
Yeah.
Copy by today, Lord.
Today.
not with
A list on 9th of August along with WP number, which one?
10 that. Just know your lot.
10, same, that WP number. Yes.
Pledge.
So, Mr. What is the lesson, young man? Best point first within 2 minutes. Otherwise, judges get impatient. Yes,
please.
please.
This PL has been filed, challenging the memo at page 29. Whereby, the respondent decided to regularize 234 shops, which is of very prime value, treating them as petty vendors. But this was heard on 7th. On 7th it was heard, and he was directed to implement the beneficiaries of the GO.
234 shops, you are
On
directed.
7th, I have filed that I also. To implement
We'll issue notice of this IA to propose respondents
and
heard on the question of admission. Heard on IA 2 of 23. Issue notice of aforesaid IA to propose respondents. Then what personal service, whatever usual thing, right?
IA please to receive additional documents.
That we will receive anytime. No problem. First, let them be there. How can you seek a direction behind their back?
No.
Then you should have, we should dismiss it probably, petition.
Last time also.
Not impleading necessary parties. You are seeking a relief against the persons who are not parties to the petition. Therefore, petition is dismissed should be the order. Instead of, please take steps for service to these people.
Obliged.
Is there affidavit filed? No.
1 week time may be given this matter.
Learned counsel for the petitioner prays for and is granted 2 weeks time to enable him to file a better affidavit in compliance of the order dated 7/23.
Much obliged.
May I please?
Yes. No, give it. No.
That's 2 weeks for compliance.
Office will give. We come up, don't give date. Don't, until unless we say don't put the date. After 2 weeks.
Office will give the date for the- They will have this introduction. Yes.
Come up.
May I please?
So, Mr. Who decides whether funds are required or not? You will decide. This court will decide.
Petitioner is not.
So, no, this is according to you an unnecessary expenditure incurred by a local body.
Yes.
The state government has supervisory jurisdiction over the local bodies or not? You approach them. The government, this local bodies under this municipality act, there is a provision saying that there must be which provision?
My grievance is your last.
No. Which provision?
The allotment of funds by the government, your last. There is
No, the government exercises control and
Exactly.
can issue directions to the municipality. You satisfy the government that this is an unnecessary expenditure, right? The government will adjudicate instead of court adjudicating. We don't have, powers of judicial review are limited. You withdraw this petition with the liberty to approach the state government.
Yes.
Heard on the question of admission after arguing the matter to some extent. No, in the grievance of the petitioner in this public interest litigation is that that without any necessity, comma,
Nandivama, your
whatever,
Nandikonda.
Nandikonda municipality
No,
has
Nandikonda municipality,
Nagarjuna Sagar,
municipality.
Nandikonda
How is it a municipality?
Sagar the Sagar
How is it a municipality?
is promoted as municipality. This year.
Pedavura Mandal municipality.
so and so municipality has sanctioned
May I please?
Short grievance of the petitioners is that they are mirrored adjacent villages.
Personal interest. How is it the early people belong to some political affiliation? How is it not personal interest? Allegation maybe we live in the office of no, but I think we have to the office subject.
Heard so and so office objection is overruled. Issue notice.
Yep.
Let despite order dated.
Which came up the other day,
Ah.
by mistake, it has been listed before this bench. It will be listed before the other bench.
Let the petition be listed before a bench in which one of us write his lordship's name is not a member.
Your lordships, it please your lordships. I beg to represent your lordships. Your lordships, the writ appeal filed before your lordships is against the learned single judge's order, where having stated that the award paid just based on the enjoyment survey without any award under section 38 being passed, your lordships, is not correct. The learned judge, however, stated that steps may be taken for compensation to be granted, but however has stopped short of the prayer itself, in which case the preliminary notification itself has to go, your lordships. If your lordships may first come to the order copy, your lordships, specifically the final portion on page 44 to 45, your lordships.
So you had preferred an objection pursuant to the notification under section 11(1).
Yes, your lordships. Yes, your
What happened to those objections?
Your lordships, those objections were rejected, your lordships.
So then you filed a petition challenging the notification under 11(1).
Yes, your lordships. The petition is
So this
challenging the,
final notification is issued under 11(3).
Yes.
then. So 11(3), give 2013 Act, madam.
Let's see, initially at the time of
Your
Young Mallards, there was no challenge to 11(1). But it was filed only stating that they are trying to disperse the petitioner. Thereafter, Mallards, after counter and additional counter, they have sought to amend the prayer. Mallards, as in fact, this honorable court, Mallards, by the interim orders, directed the authorities to consider the objections of the petitioners. We have addressed, Mallards, all the
What
objections.
has happened? Subsequent notification has been issued.
No, Mallards.
no,
The objections, Mallards, were the objections raised by the petitioners were addressed, and then Mallards, we proceeded with the Mallards inquiry. At that stage, Mallards, there
if
was
I may
Yeah.
state, your lordships.
Just, we will hear you, madam.
Yes,
It
yes,
can't be,
yes.
no order will be passed without hearing you.
Yes,
That's
sir.
an assurance, but we are just trying to understand the facts.
If your lordships would allow me, I'll state
Please
chronology.
go ahead. Yes.
The chronology of what happened, your lordships.
You should have done well to give a synopsis, 1 page, saying this has happened, what wait. Well, go ahead, yes.
Your lordships here, your lordships, pursuant to what the council has stated, your lordships, the award was, rather the compensation was given to others, completely third parties who have no concern with the land, even prior to the preliminary objections were disposed of, your lordships. And that too not pursuant to any award, general consent awards or general awards. Under section 30A, some award requires to be passed. Here, simply based on enjoyment survey that the Honorable Learned Single Judge has clearly recorded, they have just, without doing any kind of due diligence as to the ownership of the land, etc., they have just compensated third parties, your lordships. When we made the objections in time, they did not consider. Pursuant to this honorable court's orders, they were forced to consider the objections and then pass antedated orders as far as declarations is concerned. The preliminary notification itself is challenged and has to go, your lordships. And the learned single judge has just stopped short of declaring the preliminary notification as illegal. If I may read the order, your lordships.
Yes, madam.
Yes.
Our challenge is confined to challenges to 11.1.
Yes, your lord.
So that has been rejected.
Yes, your lord.
Why it has been rejected by learned single judge?
Your lordships, the learned
No,
single.
please tell us why, what grounds it has been rejected by
Your
learned.
lordships, the learned single
Judge
judge
to you.
has only on page 44 stated that acknowledging the fact that passing the award in favor of third parties without doing due diligence and only based on enjoyment
No,
survey.
madam, this thing, part of the, why we have to intervene because we want to tell you.
Yes.
Learned single judge has held you entitled to compensation, right? You can make a claim with regard to compensation which will be adjudicated.
Yes.
Therefore, now the issue is only this, whether section notification issued under section 11.1 2013 Act is valid.
Yes, your lord.
Single judge has assigned some reasons for rejecting your challenge. We are asking you, what are those reasons on which your challenge to 11.1? You had said that it's vague. This thing that all has been repeated.
The only reason is the data compliance situation, your lordships. The learned single judge has stated that because compensation or whatever compensation has been given to third parties, having stopped short of declaring the 11.1 illegal, the learned single judge has stated that you also try and claim compensation, and if any disputes, they will address it. 11.1 itself, your lordships, is antedated and it's illegal. And there are orders of this honorable court itself where it has been stated that the antedated 11.1, your lordships, the extensions.
1 minute, give us one.
Yes.
We'll hear you, madam. Don't worry.
Yes, yes, yes. 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 I'll read out this. under Rule 19.
What happened to his objections, Mister, when they were rejected?
My lords, way back on 30th July 2022, and they did not choose to challenge that.
28/5/22.
28/5 and 30th July.
All.
And my lords, page
One
13
minute.
and.
Only one, she has to be heard first.
Yes.
Her appeal. We only want one fact.
3rd July and 28th May 2022.
What is the date of preliminary notification?
31/1/2021, your lordships. 31/1/2021. It's on page 138, your lordships.
Yes. Yes, the order otherwise is in your favor. It,
Yes,
otherwise in the sense, partly in your favor that the learned single judge prima facie has recorded a finding that the compensation which was paid to persons in respect of 37 acres of land is prima facie illegal.
illegal.
But that question was not adverted to because you had not implemented those people who had received compensation. Despite that, you have been held entitled to claim compensation in respect of 37 acres as well as remaining land to which you are admittedly entitled.
Yes.
Now,
yes.
therefore, the challenge to the issue is only on what ground you are saying that 11(1) should be quashed.
Your lordships, the preliminary notification
And-
was,
Yes.
if your lordships.
Please.
Can I control?
So now you can argue. You have understood, right?
Yes,
Now our
yes.
query, then please proceed.
Your lordships, the preliminary notification was issued on 31/1/2021, which is on page 138. Completely on the names of third
Which
people.
1:1.
138, your lordships.
Yes.
138.
Yes.
Completely on the names of third people, or rather third parties who have no association, title, or any semblance of any other association with the land. Then, your lordships, we filed objections well within 60 days, the mandatory statutory 60 days. The dates of our objections are 30/3/2021. The preliminary notification is 33 March 2021, your lordships. That for your lordships review is on page 142. Now, your lordships, when we filed our preliminary objections according to the statute well within the limitation, as well as informing the authorities that we are the owners and the notification ought to have issued on our names. However, for 3 itself, even before the completion of the mandatory statutory 60 days, then any objections can be received by me or by the people who have been notified. On 4th March 2021, before the expiry of 30 days itself, they enter into a 30A agreement with the whoever is there on the land, the enjoyment survey.
Agreement for what?
For payment of compensation, consent awards.
State government gave the consent of
This is under the 2017 rules.
Yes, yes, your lordships. 30A, a state amendment, acquisition of land by state government by entering into agreement. This is well within the mandatory.
So what happened to your objection, madam?
My objections were not considered for the entire 1 year. And more importantly, your lordships, no consent award or general award has been passed in that entire 1 year, more than 1 year.
Till today?
Till today, your lordships.
What happened to your objections? They must have passed some order. Please tell us the dates.
I filed a writ petition. I filed a writ petition, and then pursuant to the interim orders on 3/7/20.
Which writ petition? This
writ petition, your lordships, the impugned writ petition.
When did you file the writ petition?
I filed the writ petition. I filed the writ petition on 22nd, 4th, 2022.
22nd?
4th, 22 April 2022.
Then what happened? Interim order?
The interim order during disposal of my object.
Date
is 3/7/2022. Objections were disposed of.
Directing disposal of.
The objections. So anyways, it's a.
Yes. So when objections were decided after this order?
The objection.
May and
3/7/2022. It's on page 712.
he told us some date in May and something. 30th July 22, madam.
3rd July, my lord.
3rd July, your lordships.
28th May and 30th July, right?
3rd July, 3rd July, I'm sorry. 3rd July, it's 3rd July.
28th May 22 and 3rd July 2020.
Lordship will get them at page 712, my lords.
712. It's only 3rd July, your lordships. Yes.
Right. Yes.
Yes.
Then
Obviously, the objections were disposed of, stating that the compensation has been paid and we are not entitled because our names have not been mutated, etc. Here, your lordships, throughout, the reason why I'm saying the 11-1 also should go is not just because my names were not included. My name as the owner.
So what are the challenge to 11-1? If you can tell us 1-3, how many grounds you have and then elaborate.
Yes, your lordship.
Because
first challenge is that our names were not included in the preliminary notification, and we have made objections to that.
Yes.
And the objections were not considered in time. The second and most prominent objection here is that, your lordships,
decided in time means statute provides a time that within how much time they should, like if you file objections.
The statute
Understand the query. Then.
Yes.
Then only you can answer.
Yes, your lordships.
Always be very attentive to the query of the court because we have to write an order.
I'm obliged, your lordships.
You may feel that I'm better prepared than court, but our order.
No, your lordships. I'm obliged.
What will matter is what we write.
Yes.
Not you. Otherwise, you would have signed it, allowed, and given it to him. But that won't matter.
I'm obliged.
Please listen
Yes.
carefully. So, statute provides a time limit size that after objections are filed within 30 days, they should decide. Nothing like that.
No, no, your lordship.
So, you are saying not decided expeditiously.
Yes, yes, your lordship.
You are required to file a writ petition.
Yes, your lordship.
Then second submission.
I filed a writ petition after more than 1 year, and even in that time, and even until today, no consent award, no general award has been passed. Consent award in favor of whoever third parties they have given amount to.
Does it say that within such time they should file the, like 11A provision is there under this 2013 Act?
Yeah, yes, your lordship.
Like, you know what is 11A of 1894 Act, you know, right?
Yeah.
If no award is passed within period of 2 years from the date of declaration under section 6, the proceeding lapses.
Yes,
the
your
provision
lordship.
like this.
Yeah, your lordship.
After 11-1, if no award is passed, no consent award or general award is passed, the proceeding will lapse. Is there any provision under 2013 Act?
Yes, your lordships. Section 19(7), your lordships. Section 19(7) of the 2013 Act states that declaration has to be passed within 1 year of the preliminary notification. I will, if I may read the section, Your Lordship.
That's what you should do.
Yes, Your Lordships. Where, if I can. Publication of declaration and summary of rehabilitation and resettlement. Section 19(7). Where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded, provided that in computing the period referred to in this subsection, any period or periods during which the proceedings for the acquisition of the land were held up.
All right. On the strength of 19(7), it has been rescinded.
Yes, Your Lordship.
And it has, according to you, not extended.
Yes, Your Lordships. Yes, Your Lordships.
According to you, not extended. We will hear them whether it has been extended.
Yes, Your Lord. If I may only, if Your Lordships would only permit me the next step. They have issued an extension that is beyond the time.
When?
It is antedated. I will just take Your Lordships to the specific.
First of all, when extension issued, then antedated. You are saying simultaneously.
Yes.
Tell us the date.
The extension, according to them, was issued on 28/1/2022. 28/1/2022, which is on page 499.
They means who?
The authorities, the respondent authorities.
Which authority?
The land acquisition, the authorities, Your Lordship, the revenue authorities, the district collector. It's on page 499. It has been issued by the district collector, Your Lordship.
Appropriate government means district collector, right?
Yes, yes. However, the same is antedated because of the fact, Your Lordships, it was uploaded as required in May 2022. That upload for Your Lordships is on page 510.
Uploaded in May 22.
Yes, Your Lordships.
When?
Your Lordships, it only shows May 2022. The date it was uploaded onto the website. If I may further
We are just
elaborate.
trying to see when you make a submission, we try to test it, right?
Yes,
So we
yes,
are
Your
just like there is also some we were just wondering, a thought came to our mind. There is a distinction, like some time gap between the orders which we pass and its uploading. So here in the court also, like
yes,
we come across that Your Lordship has passed the order that day, it has not been uploaded. So many cases. So can it be say that? Can we say that it has been subsequently created?
Lordships, it was subsequently created because the act does not speak for the same.
That is not been. Like the original notification, then they issued 1911, it was paper.
The third proviso.
Whether it was published after 28/1?
No, Your Lordships. No, it was the first.
Where have you stated that there was no publication?
Notified and uploaded.
Yes.
If I can only elaborate further on his Lordship's question, it was the date, according to them, allegedly is 28/1/2022.
Yes.
And then it was uploaded on page 510, Your Lordships, in May of 2022.
510.
510. Page 510 is the upload onto the computer.
Yes.
Which only says May 2022.
All right.
Your Lordship, specifically the third proviso, section 19
We have seen that.
specifically states that.
We have noted down third proviso.
Yes, Your Lordships.
Yes.
And then, Your Lordship,
Next
the publication, the gazette of the same is in violation, the gazette of that extension. The extension also has to be notified and gazetted.
Where is that requirement?
Page, it is under section 3V. 3 subclause V, and the gazette is on page 761.
Section
3 subclause V.
B.
V as in victory, your lordships.
We.
V.
Notification.
So where do we get it notified? It's under 19.7.
19.7.
Got
Not
it.
provide.
Not provide. Correct.
Lordship.
Got it.
Yes.
Yes. Anything else?
Notification is under 3V. 3.
Got it.
Section 3V.
Yes, yes,
Which
it's
is
required.
to be published and notified in the
Madam, we have read 3V. Next.
in the Telangana Gazette.
Right.
That too has been done.
Not been done.
They claim has been done, but which is fraudulently done, your lordships. 761.
761.
761.
Fraudulently done.
Yes,
No, when it has been published.
your lordships, 761.
When? Please tell us.
762. 28-1, they claim this Telangana Gazette has been published on 28-1-2022. However, this Telangana
Page, madam. Which page?
762, your lordships.
760.
Same, number 41 of 2022.
Oh, yes.
Your- Okay. Seven, your lordships have it. That, your lordships, is a manufactured gazette. It is not the authentic.
Where have you taken this ground in the petition?
Your lordships in the writ petition.
Where have you said manufactured gazette? All these things are serious allegations, right?
Yes, your lordship.
Orally, no oral submission can be made. Petition, which paragraph? Writ petition. And what is there? So it's a manufactured gazette forged document.
Yes, your
Where is the pleading? What is their response? What is the finding of single judge? Any other submission apart from this matter? That's it.
Your lordships. Yes, your lordships.
So we
Your
will
lordships
elaborate
was-
on this, but come to next round. Any, if any,
Yes, your lordships. It's
the other round. You just briefly tell us, then we can elaborate on this. We need to hear you.
document, your lordships, the forged document, one of those, your lordships, all those notifications are already under stay under the orders of this honorable court, where this honorable court has clearly stated that they have to be, has called for the records and has
Where,
said
which
that an
petition?
investigation. In IA? In IA 3, we have filed.
No, first. Acha, all right. So before proceeding further, you tell us in where have you in writ petition said
Yes.
that this is a forged document? Who has forged it according to you? Or you don't know who has
Your
forged?
lordships, page 40 of the order records the same, your lordships.
Huh?
Page 40 of the order.
No, petition, madam. There has to be averment. You know, they are pertaining to fraud. What is the requirement of pleadings?
Yes, your lordships.
Just like verbally, you can't say anything. Oral is all fine. You show us from where have you said that it is forced?
Your lordships, I'm instructed that
No.
averment.
Why I am insisting, because speaking for myself, in 14 years I have heard and this argument for the first time that the notification issued by the state government is forced. Very new argument to me. So I'm taking it with a pinch of salt, but to tell you honestly, where in petition you say
The land acquisition, the new act itself is in the this thing of progress,
forget
your
about
lordship.
this. We are on a question of fact pleaded by you.
Your lordship,
This notification published in the Gazette is a forced document.
your lordship,
Which
these documents were placed. That is what I'm trying to answer, your lordship.
simple question. Simple question to you is, which paragraph of the petition? Tell us. What have you pleaded about this forced thing?
Your lordships, I'm trying to answer that.
No, answer. Point out from the petition, madam.
I'm exactly trying to do that, your lordships. What I'm trying to,
Page number. This para of the petition is the
your
answer.
lordships, these documents were placed on record after the filing of the writ petition. These
Then
were made as
then
part of.
say no averment.
Yes, your lordships. Then it was not pleaded. However, it was recorded. It was pleaded
Not-
during my oral
Not
submission
pleaded oral submission.
and oral submission. The
Then
same
we will
is-
consider what
Yes.
is the effect of an orally saying it's night, 6 PM in the evening.
It has been recorded by this honorable, by the honorable single judge, your lordships.
So may have been recorded, but there is no pleading.
There's no pleading because
Fine.
the documents, the reason is that the documents were placed
All
on.
right.
Have you at least taken a pleading that it has not been gazetted? In your pleading, please show us that pleading where you have at least said that it has not been gazetted and what is their counter to that?
It has been gazetted. No, 28.
That's what we should do. No pleading, whether it is gazetted or.
No pleading, right? Not gazetted.
As
Fine.
far as it was.
Next submission. We'll
Not
deal with.
fraud, at least have you pleaded that no gazette has been issued? What is the answer to
petition.
that? In
Your
the
lordships,
petition?
page 53, your lordships.
Which para?
Page 53, para 6, your lordships, 6.
Please read.
I submit that objections to the preliminary notifications under 15 of the Act 30 of 2013 were filed by the petitioner firm on 31/3/2021 before the district collector, and copies being marked to the land acquisition officer cum RDO and Tahsildar well within the time limit of 60 days as prescribed under the section 15. As per the provisions of section 15 of the Act of 30, the district collector has to give personally hearings to the objectors and submit his report to the government, wherein the government has a final say. This statutorily prescribed procedure has to be mandatorily followed by the acquisition authority.
No,
before
madam,
proceeding was-
in this para, there is no averment.
That's not. What you'll have to answer is, where is the plea taken by you that upon the expiry of the 31st January 2022, 30th January 2022, the gazette has been 11/1 notification has expired. Since it has no gazette has been issued extending the time limit, where is the plea in the entire averment? We could not see.
Your lordships, there has been an amendment of prayer as far as the 11/1 was concerned.
No, madam, this thing,
Arguments as
you
far-
see, madam, when a query is being put to you, you say that I don't know, I need some time, understandable. But saying anything
Your lordship,
will not help. What we told you in the beginning,
Yes,
that
your
what we write matters.
Yes, your lordship.
If you don't answer, the consequences will follow.
Your lordships, respectfully, there is
No,
no
this thing, brother has put a very pertinent query, answer that. Or you say that presently I don't have an answer.
Yes, your lordship.
I'll get back to your lordships after this thing, your instructing colleagues tells you.
Yes, your lordship.
That is understandable.
As far as
Not saying anything.
that averment is concerned, your lordships, my respectful
This is
submission,
what,
there is no
what should have come from you.
averment, there
This
is
is
no
what
plea.
should have come from the beginning, that this is what it is based on a subsequent event, therefore there is
Yes.
no pleading.
Yes, your lordships. It is based on a subsequent event which led to amendment of prayer as well, your lordships.
But we are putting words in your mouth, right?
Your lordships, I was
Yes.
trying to see if there is,
Yes.
yeah.
So there is no pleading, right?
There is no pleading to that extent, your lordships, because your
That not gazetted is not a pleading, and
in the
no, just a
writ
minute.
petition.
No pleading that it's a fraud.
Yes,
All right.
yes, your lordships.
Then, yes, next. What
And-
is,
And the same, your lordships, I was
Hmm.
on the ground of, the same has also been challenged in this honorable court and
what has
pursuant
been
to
challenged? What has been challenged?
your lordships, the fraud aspect of it, the fraud aspect of certain extensions. In this case has been challenged and orders
You.
also have been passed.
By you,
Yes, your lordships.
in
By
a
me,
petition.
in other writ petitions,
How
your
can
lordships.
you, this thing, I mean, file one petition, suffer an order, then file another petition,
No, your lordships.
seeking another relief?
Third parties. Because under the notification, various.
You have not filed. She says, I have filed.
No, she only filed, but in respect of other parties. Under the.
Not by the petitioner.
Your lordships,
Other,
not by the this
Say
petitioner,
so.
your lordship.
then say so, madam. We are taking it that he has filed. Say so that
No, your
That
lordship.
this petition, but some other landowners.
Yes, yes,
You have to be clear. You say some other landowners have filed another petition.
yes, yes.
We are thinking that I was asking you whether or not constructive res judicata applies.
Your lordship.
How can petition file bits and pieces? One relief, one petition, second relief, third petition. You can't do like this, no?
And this honorable court,
So, who has other landowners have filed a writ petition?
your lordships, in IA 3 of 2023, in this writ appeal, I filed those orders for your lordship's review.
We are noting down, madam. Tell the number. Which writ petition has been filed? Other landowners.
It's writ petition 6347 of 2023. And it is at from page numbers 19 to 24, your lordships. It's in IA 3.
What is the relief claimed, madam?
Your
Tell
lordship,
other landowners have filed this petition claiming this relief in which this interim order has been passed. This is what you want to say.
the relief claimed is that, your lordships, to set aside all of these notifications as they were based on fraudulent entries and fraudulent gazetted documents. In that, certain interim orders have been passed, your lordships, where first time round on page 20 and 21, this a learned single judge has stated that has called for the records, your lordships. And after that, another interim order was passed on page 22nd and 23rd.
Arey, mister, then you should have said no, this instead of arguing the whole thing. Madam, please, what should have been your submission? Within 1 minute of this case being called, that the issue involved in this appeal at the instance of other landowners is pending in another writ petition. And I will move an application seeking analogous hearing.
Lordships permits me,
Now you are seeking an adjournment, right? That
Lordship permits me, my lords, the
so
very,
you are not seeking this thing deferment of hearing, right?
my lords,
And is
Not seeking. I'm
Fine.
ready to.
Go ahead then. Yes,
Your
we'll
lordship,
hear. Let her conclude. Yes. Which WP? What interim order? What interim order, madam?
your
Which-
lordships, the interim
Which
order,
interim order?
your lordships, on
Eight.
page 22nd and 23rd is the interim order.
Ah.
Before that, I will take your lordships to the first interim order on page 20.
What is it, madam? Please tell us.
On page 20.
Page-
On page 20 of IA 3. Page 20 of IA 3. There is another IA that was filed, your lordships.
your lordship may see page 19 cause title and the writ appeal cause title. Now, same person has filed. As the writ appeal is filed by managing partner Bukka Ramesh, and page 19 writ is filed by same Bukka Ramesh, son of same person. And that too after the
Balaji
disposal of the
Spinner.
petition.
Partner. Same.
As a managing partner, he filed this writ appeal.
His other lands also were acquired in his personal capacity, your lordships, and several of those.
To say that. All right. We thought some other person.
His other lands also were acquired, and that is the reason he
This
filed
firm-
another writ
Firm is
petition.
the owner of several other lands. This person.
Yes, your lordships. 78 acres, your lordships. Out of that, the land that is being acquired is only 42.
This argument that that's all that we only form and see together. Yes.
Page 20, this honorable court has called for the records, if I may read, your lordships. After going through the material on record, on page 20 I am,
Yes.
a decision will be taken with regard to the notice issued on so and so. Learned so and so for the petitioner submitted that the district of Siddipet gazette notifications are being maintained without following proper procedure, and most of the gazettes are antedated in order to fraudulently take away the lands of the petitioners. After going through the material on record filed along with the writ petition and noticing certain discrepancies in the dates of the gazette and gazette numbers, as pointed out by the learned so and so, this court is of the opinion that the gazette notifications along with gazette note files mentioned in the table at page 14 to 17 in the writ petition be seized immediately for perusal of this court. learned so and so representing so and so is directed to produce all the relevant gazette notifications in a sealed cover. After that, your lordships, that honorable court.
That's it.
Yes.
After that, your lordships, after that hearing, after that order, in the subsequent hearing, another order was passed by.
So what happened? This petition is pending, right?
Yes,
So
your
you want
lordship.
to only tell us by all this that issue with regard to validity of gazette is pending before
Yes,
learned
yes, your
secret judge.
lordships.
Fine.
Because of the fraud, your
Despite
lordships.
that, you are proceeding ahead with this writ appeal. You said I am not seeking adjournment. Fine, then next submission.
Your lordships, and the fact remains that until this day, a consent award or a general award has not been passed. Hence the fact
That's
of,
it.
hence the fact of the procedure being open
That is-
and the preliminary notification being invalid
Yeah.
because of.
That we have appreciated.
Yes.
It is rescinded.
The another aspect is that, your lordships, GOMS 35, which states that the rehabilitation and resettlement for an irrigation project should be read as part of the irrigation project itself. And hence it is exempt from any kind of social impact assessment under section 10, etc. However, this honorable court also, the writ petitions are pending where it has stated that 35 cannot be made applicable to.
No, madam, this please understand the scope of the challenge in this appeal is confined to validity of 11.1.
Yes.
What a rehabilitation, you are traveling beyond the scope of the appeal.
That is an extension, your lordships.
We are not dealing with that. What happens?
Yes, your
who is rehabilitated? It's not. We are only examining validity of 11.1.
Your lordships, the 11.1 is illegal. We have not been paid any compensation so far. Somebody else has been paid compensation, and construction activity is going on as we speak for setting up the rehabilitation colony. If that activity is not stopped, we will face irreparable injury, your lordships, because the very fact that the entire acquisition proceedings after 2 years also is still open, your lordships.
That's it, madam. Anything else?
Yes, your lordships. If anything in rebut.
Yes. Mr.
Your lordships, one last aspect is under 30A also a consent award requires to be passed, even if it is for the third parties.
So you have understood, Mr. Noted down, or should we tell you?
Yes, I'll assess that. Now, before going to the submissions, my lords.
No. What she says, preliminary notification under 11.1.
Yes.
Bad, because names of third parties are mentioned. Then you have, even before decision on objections, you have entered into an agreement with third parties for passing a consent award, which consent award has not been passed till today despite lapse of 2 years. Then objections, this you have decided the objection of the petitioner pursuant to an interim order, you kept it pending for a long time. Then notification that the proceeding, the preliminary notification under 11.1 is rescinded because of 19.7, the time having not been extended, even assuming it was extended on 28/1/2022, it has not been gazetted. Right?
As before going to the merits of the matter, my lords.
No merits. These are the points.
Only
and this thing, what you say, extension of time is another extension of time is antedated as you have uploaded it as required under the third proviso only in the month of May 2022. And this gazette notification also is antedated. This is what all she has said. And the issue with regard to this validity of notification at the instance of another landowner, like he is another landowner for the same person, but another owner, because land involved in those writ petition is different, is pending adjudication before single judge, where you have been asked to produce record, etc. Now, yes.
My respect submission is the 11.1 is, my lords, to provide rehabilitation, my lords, of 8 villages they were minutes affected due to Kaleshwaram project minutes. Total 600 and odd acres minutes were required to provide rehabilitation for 8 villages minutes. And in the process, the authorities have identified survey number 326 and 321, which according to us, survey number 326 and 321.
So that is correct. 11.1 is issued. We are post that.
Which according to us is recorded as a government land to an extent of 390 acres. And there were minutes
These
assigned.
people don't have a claim.
Yes, that is what we have said minutes once. And there was a ban. This
This is not the ground on which you have succeeded.
but they succeeded in getting registered sale leads from the assignees from a different sub-registrar. But they are holding sale leads. I am not disputing that. They are holding sale leads.
No, if the land belongs to the government, why did you notify it? You
No,
could have.
there were assignees which are in possession of the property. They are continuing. That is the reason why we have.
Please understand their question, their title. You cannot question in a appeal preferred by them.
I am not questioning.
This is what you are saying. Fraudulently obtained sale lead. Can we hold that the sale lead is null and void in this writ appeal?
Not at all. I am not.
Then,
They are admitted.
for your benefit, though we were not supposed to do so, for your benefit, we read out what she has argued, what we have noted. Instead of answering, you are saying that their title is, they don't hold title.
To answer the submission that their names are not shown in the preliminary notification, their own admission in the affidavit at paragraph 8, that their names are not mutated in the record. That has been admitted by the petitioner. Paragraph 8 of the affidavit.
Which page?
On page 53 minutes. And also in the grounds. Ground number 8.
All right. Which page?
Page 53 minutes.
Then next ground. Next submission.
As per the
Therefore, they were aware no prejudice has been caused.
No prejudice has been caused, and on that ground alone, 11.1 cannot be satisfied. Is my respective submission.
Fine.
That has
Next.
been, it's a settled law 1996 Supreme Court.
What 96 Supreme?
I'll produce that copy. And the second aspect, no consent award past is concerned. We have paid compensation. We have conducted an enjoyment survey. Basing on that enjoyment survey, we found that certain third parties are in possession to whom we have paid compensation, and we found that the petitioner is in possession of the property only to an extent of 8 acres. And their names have been shown in the preliminary notification, 8 acres, 30 guntas and odd.
8 acres, and you will pay compensation to him.
We have said so in the counter millets.
All right.
And as regards the disposition of millets,
Meaning the 37 acres, 33 acres, they are entitled to make a claim. That also single judge recorded finding. You have not challenged it.
saying that millets 12.6 pursuant to the orders of the learned single judge.
Now come to 12.9, 19.7. What happened? 31st January 21
Page
preliminary.
40 of the order, learned single judge records a finding that there is an extension of time on 28/1/2020. Page 40 millets.
40.
As this is answering the ground number 4 millets raised by the petitioner.
Which para?
Paragraph 16 on page 39. It starts from.
Yes.
The fourth ground stating that the preliminary notification issued under section 11.1 of the Act 2013 stand rescinded for want of making a declaration under subsection 1 of 19 of the Act within a period of 12 months on the ground that extension of time in terms of second proviso to subsection 7 of 19 of the Act was an antedated and notified at a later date is concerned. This court is not inclined to consider such objection as admittedly there is an extension granted through proceedings dated so and so.
All right.
And the same was published in Telangana.
Requirements of this thing. First, you have told us that time was extended. Now, whether it was published in the manner required under 19.7.
For yet another reason, the learned.
No.
Yes, ma'am.
Third proviso. recorded in writing shall be notified to be uploaded. Notified means gazette.
Yes, my lord. Gazette, my learned friend has shown, my lord, page 760. One.
Ah,
762 my lords. This
Yes.
was published on 28/1/2022 in the Gazette notification
28/1,
22 itself,
page.
page 762 my lord.
Ah, yes.
Extension
Where is the original? Produce the record.
and one more aspect I'll state to your lordships my lords.
All right, you produce the
And
record.
one more aspect I would like to bring to your lordships notice.
We are granted. How, when will you produce the record?
Only one
How?
aspect.
Yes.
Similar
put this-
request, similar direction is given by the learned single judge in other matters. So the record is anyhow, you are directed to be brought to court.
That order is
Before-
concerned subsequent to the disposal of the writ petition is one aspect.
What
Second
I-
aspect,
What submission you are making?
was the writ petition came to be disposed of on 10/2/2023.
Ah,
And Malas, the order which was relied on is Malas of March 2023. Subsequent to the disposal of the writ petition.
fine. But we are asking you,
And
right?
another aspect, Malas, the 12/6/2023, we gave notices pursuant to the orders of this court.
Ah.
And they have appeared before the authority and subjected themselves, they have laid a claim. We are examining that, Malas. Lordship may kindly take up the IA3 Malas,
No. Fine. We have got it, but you produce that.
Very well.
Mark, yes, madam.
2 weeks, Malas.
Date you tell us. Think about it. Tell us the date. In the meanwhile, yes, this intra-court appeal is filed against an order Convince your friend now that he should produce at a shorter date.
And
We'll do so, no problem.
And in the meantime, your lordships, in order
We
to.
could have very well passed the order today itself, madam. Yes.
If
we
your
have
lordships
understood.
would allow status quo until that time, your lordships.
Nothing is being done.
On the construction activity, because otherwise.
Who is raising
One
construction?
second. You are dispossessed.
Yes,
Now, what you are asking is whether 11-1, the earlier
Yes.
11-1 goes. Nothing prevents them from issuing a fresh 11-1.
yes,
So what happens? Your compensation increases.
yes,
Then what?
That is the only,
yes,
please realize, be alive to the ground realities.
yes.
The land has already been utilized
Is being.
and has been allotted to third parties. Even if you succeed, they will very well be well within rights to argue about molding of relief to be provided to you. Think about it. You are only contesting the claim in terms of money. In case preliminary notification goes, they will have to issue fresh notification 11-1 and as market value probably we don't know.
We'll only be wading in the difficult waters.
Brother,
You will only be wading in the difficult waters.
all right.
Because water
We
is
wanted
already there. So you'll only be wading in the difficult.
We wanted to finish today's proceeding in so far as this case on a lighter vein. Okay. Yes, madam.
I'm grateful, ma'am.
Yes, your lordships, I'm obliged.
Please,
Yes, please.
item 11 and 12, my lord, I appear. And my lord, all these, my lord, matters, 4 matters, my lord, I believe, my lord, in our matters, my lord, the crux is, my lord, that GOMS 111, my lord, that based on GOMS 111, my lord, or
No, Mr. This what is happening is why you are seeking time for filing reply, whatever vacate stay.
we filed our reply, my lord. And my lord, this.
You want a direction that your application for consent for permission to run what some mobile unit is pending.
Not the file.
Crushing unit.
Unit.
So the challenge was more saying deleting this, in order to this is undertaking that and the state only. Saying that they constituted a committee in terms of GO 69. Until such time the committee makes a recommendation, they will not get anything. Will contribute. The 10 kilometers of this limits. No activity shall this thing. So they said what in our only is being exempted. But then what happens with this thing? It's tripping one relating to the spring lakes of which are drinking source. Like some which will not be no construction or no industry shall be there. So
He is within that zone.
yes, he's within that zone. 86 villages are there, but we have employed without the list of villages. Triple zone is at 53 to 57.
So, Mr. You are
I appear.
1906. Please see what is the petition. That's what we told you. 1906.
I am not appearing in.
Not appearing. Who appears 1906? What? Yes. No count. What counter?
See, may.
One.
The direction is no industry shall come up within the area of 10 kilometers, 10 kilometer of the field lakes. Based on the Honorable Supreme Court judgment, 111 GO was issued. 86 villages or 84 villages.
84 villages.
Are notified, and this particular village is also one among them. They wanted to de-notify this village. But by this court, before this court, the government filed an undertaking affidavit. They have constituted a committee in terms of GO 86 or 89. And
69.
since the committee gives a report, no action will be taken and the status quo would be maintained. This is the factual position. And as of today, we have not at least seen any report being placed before the committee being brought to our notice. And that the particular village has been excluded or de-notified from the list of villages which forms part of GO triple one.
But that the government has to clarify.
It's simple prayer is not to dispose of the application. The report of the PCB is that the application has been returned at all, long back. The prayer in the writ petition, my lord, is only to dispose of the application, which has been written by the PCB, my lord, as per the report of the PCB.
Okay, it has
Long back, there
written.
is no representation pending.
May I clarify, my lord?
The first one, my lord.
In all these matters, the GOMS 111 is the crux, my lord. Now, my lord, the government has a cabinet decision has been taken to withdraw that GOMS 111.
But they have given an undertaking. How will they get over the undertaking given to this court?
My lord, that we are not aware.
18896 of 2007.
That, my lord, that we are not aware, my lord. Can I have a?
I have the chief secretary's, special chief secretary's affidavit before us. Given Chudamani.
They have to, they have given time.
No, but they have disposed, we have disposed of his application, returning, accepting, rejecting, whatever.
Yes, sir, we disposal of the application first given
Nothing, sir.
on 27/5/2022, they given application. Not
My lord, in the
And what happened? What did you do?
27/5/2022, they made an application.
Correct. Then what did you do, mister?
We have
When?
returned,
When?
returned on 28/5/2000, same is communicated to them.
Next day.
Next day, my lord.
Why you have written?
Yes, my lord, they are.
Triple one.
111 GO and the.
All right. Mark the presence, mister. You are this thing, right? It can't be permitted, right? 28/5/20, this thing. Yes, Mr. 1906, WP 1906/2023, mark the presence so and so learned counsel for respondent. The petitioner, what is the unit run by you? Crushing?
Yes, my lord. Stone crusher.
The petition, the petition. For such submission, nothing survives for consideration in this writ petition, same is accordingly disposed of. Now your case, please.
My lord,
Yes.
my lord, your lordship will kindly appreciate.
Yes. What is your item 11?
11 and 12.
Please, 11 and 12, give madam. Oh, no, see, what have you said? You were showing me that we will write that. What have you said is situate in a village?
The Gaulidodi village.
Read. Village so and so. And what you don't have the ink.
Open the ink.
Ink. Give him a pen, he'll do. So, in a village so and so covered under geo, and there is a total prohibition of location of industries in the prohibited zone. Therefore, return so and so, right? No things are well. We need to keep this also his case.
I will get it from better copies.
No, but his case needs to be decided, right?
No,
Now, just now we will need it.
yes. In this also it looks.
Yes, please. Which village, Mr.?
And your lordship can take any matter.
So item 11 only?
Yes.
11. 34787. Which village?
This is also the same village, my lord.
No, that is Gaulidodi, Gopanpalli. This is,
Gopan-
yours is what in
I'm sorry,
Naglapalli.
not- that is Gopanpalli.
Yours is
But
what in
my-
Naglapalli.
This
So-
village is what now village. my lord.
So there is no prohibition.
This village is concerned. There is a subsequent amendment to the GO 111, withdrawing all the restrictions that have been made in that
Which
111.
which geo?
GOMS 69, my lord, which is filed as material page.
GOMS, there was a total prohibition, right? Which date, Mr.?
That is on the triple one, which according to him stands modified by GA.
Triple one of 96, right?
Yes.
96.
8396.
That's what I'm asking.
So not to kindly take.
That has been modified by the GOMS number 8069 dated 12/4/2022.
So what is this?
I will
12.
let's see that 069 78 79 page 78.
May I submit? Page 78. Page 78.
We have got it.
May I read?
Yes.
What's on this? This is the guideline with the committee, we will conduct, then study and it is a GO constituting a committee, not excluding the.
So GO constituting a committee.
No, my lord, your lordship. Para 3, my lord, your lordship will find.
Yes.
Considering the above fact, the Hyderabad city drinking water requirements are no longer dependent on Usman Sagar and Nepal Sagar reservoirs, which was underlying theme of for issuance of GOMS 111, dated so and so. Government, after careful examination of the matter, have decided that the restrictions imposed under para 3 of GOMS 111 are removed, subject to condition that the water quality of these reservoirs shall not be impacted in any manner whatsoever. All the efforts be initiated by the government to improve the water quality of these two reservoirs. Inter alia, my lord, so and so has to be established. Then, my lord, your lordship will kindly. A committee has been appointed. A committee is
No, read para 4.
not
In order to frame guidelines.
in order to frame guidelines and
Detailed regulations.
a committee headed by so and so. So and so is hereby constituted.
The terms of reference is
To
this.
suggest for protection and prevention of pollution to two reservoirs, to suggest both broad guidelines for zoning, including earmarking of green zones, to suggest modalities for development of trunk infrastructure in this area, to suggest various means of resource mobilization for taking up trunk infrastructure, roads, major drains, STPs, diversion drains, etc. To suggest appropriate institutional framework to take up the infrastructure and regulate the development in this area, to suggest necessary regulatory measures to be insisted while granting a layout building permissions in this area, to suggest necessary changes, if any, to be made in the existing legal framework to effectively regulate the developments in this area. These are the, my lords will, my lord, after this GO, my lord,
Yes.
After this GO, my lord, the particular area in this village where my unit is set up falls under the downstream of this lake, and my lord, these survey numbers, whether they can be, they fall out of the rigor of QMS 111 or not, and has fallen for consideration before this honorable court. My lords will kindly go to page 51, the division bench order of this honorable court.
All right, admitted for hearing. 10 and 11. Yes, next. 12, 13.
So what happened is, not skip, item number just, item number 11.
We have admitted it for hearing. You are for petitioner, right?
My request.
It requires some consideration. All cases can be decided in motion hearing.
Sorry for my time. I would like.
The result is that 12:45 we are at item 13.
I would like to say.
What you are petitioner?
No, I am appellant in appeal before the National Green Tribunal. What happened, my lord? When the CFP was rejected, they approached the appellate authority before pollution control or appellate authority here. Thereafter, not the appellate authority allowed them. Questioning that, we filed appeal before the National Green Tribunal. National Green Tribunal, while set aside the order.
You are the complainant.
Yes, I am not the complainant.
Then who are you?
I filed an application OA number third party busybody. No.
Third party busybody. Another person interested in setting up query. Rival.
No,
how does it, Mr. Once we say that it requires consideration, how does it operates to your prejudice? We don't know. You are opposing admission of the case.
Consider nor here case will be considered.
Try to bring only.
Please, Mr. Like you have been doing, please give a synopsis like this geo, this happened, this geo modified. It saves time. That's the only idea. By the time you are taking it to 120, 130, one page you could have passed on. It would have been over by now. We have to admit it because you will take half an hour, he will take half an hour, and we are sitting till 1:30.
I will prepare a synopsis and test the same before the last. Not a lot. I have next week. Not in the meantime, I prepare synopsis instead of admitting. But there is an appeal provision under National Green Tribunal Act 22 of 2000.
If appeal provision is there, then even that day also we can say that
He will go to appeal.
that can be done. Yes, come on, next.
There are judgments of Supreme Court notwithstanding admission of a petition, you can clear, right? If we find that you can be relegated to an alternative remedy, you cannot say that, no, it has been admitted, now I can't be sent anywhere. Do you want to say this?
No, my lord.
No. See, he knows the law. Senior counsel would know the law. He can't.
Right. I want to bring few facts to your lordship. That's the reason, not I.
There is a bill pending before this court.
Yes,
Mr.
With regard to 111 and GO 69. Correct?
Yes.
Larger common interest is protected, whereas you people are fighting one industry fighting the against other. That takes a second back seat as compared to public interest. Yes.
We have not passed any order according to us, any order adverse to any of the parties. We have only said it requires hearing. You will also be heard. We are not saying that not be heard.
I prepare synopsis and advise, not I.
You prepare, no. First prepare, then. Nobody prevents you from mentioning the matter.
No, sir.
Nobody prevents.
They approached the
Next case. Madam, call, it will not end.
Date may fix not.
We told you make a mention after you prepare. File an application for early hearing.
Yes.
And we will consider that and give a date.
Yes.
Do something instead of arguing after admission of the case. What you are required to do, prepare a synopsis, file an application for urgent hearing, make a mention for listing of that urgent hearing, we will fix a date. But all this 23 petitions cannot be heard like at the cost of 2005 litigant waiting. Please understand.
Yes.
You may, much to your liking, you want us to issue a lease deed here itself duly signed by me and brother today itself 1:30. But that can't be done. Fine. Fine. Next case.
Please. Yes. Next.
This order is appealable before Supreme Court, by the way. You argue there. Yes.
Yeah.
Madam, call. He will keep on standing till 1:30. That doesn't mean we will not take up any case. All 13. None appears. Oh. Yes. No, nothing same.
Same.
Ah.
You are also same.
Same. Petition is admitted for hearing. List along with friends.
List along.
I thought it's all over.
My lords, these are the matters where the petitioner is neither the borrower nor the guarantor, and property also has not been mortgaged.
So is it a secured asset?
If I may, he's filed an additional document, my lords,
Madam, these matters is repeatedly coming up before us. I mean, there's no fun in every day it is listed and seeking an adjournment.
That's my grievance.
Last time, short accommodation to seek instruction, go through the same, 4-8.
No, I'm ready with the matter.
Then say.
I'm only
Is
stating.
it the only thing is, if you are not neither a borrower nor a guarantor and a person aggrieved, then also appeal lies, because any person aggrieved by an order. So you need not be this thing. The only why we have entertained is whether it's a secured asset. Is there a document showing that it's a secured asset or no document? There's nothing to argue.
It's not a secured asset, my lord.
It's not. Yes. Which is the property, Mr.?
As per the
Which is?
records, my lord, I have filed the recital lying in the records of the bank.
No. Which is the property being put to auction, madam?
Yes, my lord, that is the apartment that the petitioner is residing in, my lord.
Tell us details.
My lord, that also, my lord, there is a dispute. The apartment the petitioner is residing in is 102.
Disputed question of fact and file an appeal. We can't decide.
Indeed, my lords, your lordship may.
Madam, it must be clearly discernible from the record that in case it's a disputed question of fact with identity, it can't be entertained. Because we cannot find out by conducting an inquiry, recording your evidence, bank's evidence, then record a finding that this is the property, all this will be done by DRT.
On the face of
We
it,
will not record evidence.
on the face of it, I'd like to show your lordship.
Then you said dispute. You are saying dispute.
My lords, on the face of it, my lords, if your lordship may kindly permit, page 26 is my sale deed.
Be specific, madam.
Page
There's nothing to argue over.
Page 32 is the scheduled property that I purchased, that is flat number 102B. Now, your lordship may see page 36, notice under 13.2. The notice under 13.2.
This is which property you have purchased? This is
flat number 102B.
No, this is Schedule A and B both.
Yes, Schedule A is the description of the building. Schedule B is my property. The flat that I purchased.
102B. All right. Then where is the sale?
13.2 notice is on page 36. This is addressed to 1P Nursing Rao. I am not Nursing Rao. I am Vijay.
It cannot be Nursing Rao.
Yes. And
which is the flat?
And the property.
Same flat.
Page 38. 101A.
You are not concerned with 101A.
But what they're doing is they're sticking this notice on my flat. That is the whole issue, my lords.
We will clarify that you will have the liberty to proceed with the property which has been notified. That is 101A. That's it.
108.
101A.
What? Mr. 38. 101A.
If I may just interrupt your lordship one more time, my lords, page 44, the notice now under 8.1, they are showing a different property there. That is flat 100A. Within these two notices issued by them itself, though they're not addressed to me, the properties are two different properties.
Mr. You are brokers with properties or what?
No, it is that.
No. So you are trying to tell us people are they are scary about opening an account with you, leave alone taking a loan. And by your conduct, you are trying to tell us that we will do all this and won't even open an account with us, right? This is the attitude. We will follow up these people. What is the explanation for doing all this?
No, my lord. That is not.
No, means file an affidavit of competent authority, we will proceed against you. Yes. Mark the presence. Yes. This is it, madam. This is how you should argue. Learned counsel for the petitioner submits that by a registered sale deed dated
The notice.
We will deal with you. This is acting like goons in this. Your officers are acting in collusion with this brokers and acting as recovery agents.
Because the notices are stuck to the petitioner's door.
And the notices are what asking you to do what, madam? Notice
Clear the loan.
Fixing on
The symbolic possession notice is stuck to my door. Initially 13-2 notice.
and what learned counsel for the what submission read, Mister? I have forgotten while. Yeah, and the notice and the notice of constructive possession has been pasted on the flat of the we are not concerned with this thing.
Since
don't-
only,
what-
since
don't, we are not history. Who did what? Just a minute. Last date also, every day we have to explain what orders we passed through. You don't understand the concept. That we asked you simple thing to tell us that the flat belonging to the petitioner is a secured asset.
One not to be, let us be specific,
Ah.
is one not to be.
Secured asset.
it is not, my lord. That's
that.
Learn it.
My lord, kindly, I mean,
No, answer is yes or no. 102B is not a secured asset.
as per my recital, that is not, the petitioner's property is not. But
What basis you are pasting that notice on her flat?
same property has been sold with two different numbers and one of which is under mortgage with the bank. It's a,
No.
it's a matter to.
Don't get into the trouble. We will ask you very inconvenient questions. 13-2, it's better to get out by saying that we will not proceed against petitioner. Because see, 13-2, you say something else.
100A.
100A.
Not one way.
101A and 81 they say 100A.
And constructive possession, you say 100A. So in any case, this thing, this thing 102B is not mentioned anywhere, according to you. No proceeding has been initiated against under petitioner in respect of flat number 102B. Where is the notice? 13-2. All right. On the other hand, learned counsel for respondent has defended the action.
Here, my lord, this matter has
We are
come
not
before the
concerned
court.
where it came before. I am concerned about myself. Second time, we don't want to add this thing. No, madam. So this thing, we will not quash the proceeding under 13-2 or this thing, 8.1, and we will say, but no action against you shall be taken.
Yes.
Right? Paragraph. We have considered the rival submissions made on both sides and have perused the record. From perusal of the notice issued by the respondent bank under section 13(2), you didn't say anything. What?
My lords, item. My lords, item 15 also similar. The flat numbers are different, my lords. The flat number is different, petition is different, and the flat number is different, but.
If what have been, you have seen the order, give the numbers.
Yes.
What, if any confusion, please ask us. 15.
Sublist.
Ah.
16 DD Vishnupuram, Vishnupuram Reddy, DD.
Madam Lord, we filed a report, but that's pollution control board is filed.
Notice, proof of notice. So, yes. Mister, you are not doing anything. People are coming to us.
Yes,
You
madam.
tell us why should not be recovered. They make complaint to you. You don't take any action. They come to us.
We filed a counter, the counter brought the report.
What have you said in the report? Please tell us.
This report by unit. Unit is.
Appears for spawn number 7.
I don't.
R7. Yes, madam. R7 who appears? No. Served.
Notice has been.
Personal notice was ordered.
Notice has been served, my lord.
Sir, have you filed proof of service?
Yes, my lord.
You want to, have you gone through the report of this?
Yes, my lord. Filing the writ petition, my lord. That is after 1 year after passing the closure order, they have now closed the crushing unit now.
So then there's a grievance stands redressed.
You have closed it, no? No.
It may be recorded. Yes.
Yes. Learned counsel. In this writ petition, petitioner inter alia has prayed for the following relief court, right? Learned counsel for the petitioner fairly submits that after filing of the writ petition, Telangana State Pollution Control Board by an order dated
on 24 on
fairly
2022, my lord.
fairly submit that subsequent to filing of the writ petition, Telangana Pollution Control Board by an order dated 18/2/2022 has
Yes, created.
You should say no.
Yes, but we close that
Report and all that counter. What counter? You should say that closed. It does not survive. 18 to 2022. The has closed the
My lord, the
what
repetition was
expression?
filed.
Illegal crushing operations being carried out by respondent number 7. In view of aforesaid submission, nothing. In view of aforesaid submission and the report submitted by the Pollution Control Board, nothing survives for adjudication in this petition. Accordingly, same is disposed of. Yes, next.
February 2023.
17, madam. Yes, madam.
Where, please, Your Lordship.
Will admit
Oh, it's coming.
the certificate.
The present writ is filed, my lord, challenge.
Counter file, you want to file any rejoinder?
I filed the reply also, my lord, in.
So then we will hear it. A petition is admitted for hearing.
My lord, one submission, my lord.
Make an application for urgent hearing, madam. All 223 petition can't be heard.
My lord, I have filed. it.
2022 now they are failing.
Urgent hearing, please file.
2022 GO, now they are approaching before this court. LL matter.
GO is of 2022.
22, GO of 22. Fine.
My lordship, but the results are.
Please file. Application. It doesn't mean that supposing you file a petition, they should file, if they file a counter tomorrow, we should hear day after. No law says. Make an application for urgent hearing, we'll decide it, taking into account the nature of dispute. You have been waiting since 2022. Next.
One submission, my lord.
Madam, call, madam, case. Don't.
My lord, one submission, my lord.
22. What case? Yes, 22.
Correct. Appearing to the respondent number 1 and 2, my lord.
No.
We filed a report in this matter, my lord. So the
You have
allegation,
not done anything.
no, my lord, in this matter, the allegation is that a particular industry has been violating
What
environmental
action have
norms.
you taken?
My lord, we've inspected and then we filed a report stating that the compliances are in place and they are following the norms, my lord. That is the report we have filed.
Yes, madam, she wants to say something, please. What?
The results are.
Madam, we granted you the liberty to file an application for urgent hearing. Or file any application for interim relief. Don't after closure or utter something like, we don't like this. We have told you it's for admission, we have admitted it, right?
Deeply obliged.
Then if you want any interim relief, file an application seeking interim relief. If you want final hearing, file an application for urgent hearing. If application doesn't come up, seek a mention memo. We will grant it, considering the nature of controversy, subject to our board, we will hear. This court is sitting till 2:30. You will argue for 45 minutes. They will argue for 1 hour. When do we decide? No other case should be taken up except NCCC certificate.
Okay, my lord.
23 petition, right?
Yes, my lord. I'll file it.
Please understand.
Yes, my lord, I will file it.
Every case can't be decided at motion stage. You are asking us to do something which is impossible. We wish that you sit on these chairs and do it yourselves. Then what will be your answer? We will know. Yes, none for the petitioner. Hearing is awaiting appearance. Hearing is deferred. You didn't tell us what is the report.
My lord, item number 22, my lord, we filed a report stating that the compliances are in place and they are following the compliances, my lord. We have filed
None for petitioner, hearing adjourned. Yes. You don't say you want to file a rejoinder?
But I had to
22.
And to 22, I have 22. Not I have the respondent.
No, correct. That he will take care. So what appear for her, so and so appear, learned counsel for the petitioner is not making any submission, hearing is deferred, list after 2 weeks.
Yes.
Here they have filed a report. You don't want to file any counter.
The report is submitted to
They say so, Mr. Ben, it's not our case.
other case is hearing where I am.
No, another hearing. She has sat down. Thereafter, this case is called. He is making. You should say that he has not supplied me the report. You are looking at us. How do we decide what is? How do we know? Please tell us that he has not supplied the report to you.
That's why I am saying.
Learned counsel for
standing Telangana State Pollution Control Board, respondent 1 and 2, man.
1 and 2 undertakes to supply a copy of the report filed on behalf of them to learned counsel for the petitioner within
We'll submit now, my lord.
during the course of the day. Who learned counsel for the petitioner prays for short accommodation to enable him to go through the same and to file a reply if so advised. Correct?
Lord, I am the next respondent, Lord, I
All
have
right.
filed my counter and I have already served the counter.
He is not making a grievance against you.
Yes.
Yes.
Obliged.
Why are you so upset, right? So smile. We have directed. Say so, Mr. Precious. Time is precious of this court.
In this matter, my lord, similar
Which
matter,
case, madam, so they don't understand, right? I speak, you also have a mic. They don't know which number is called. Huh?
my lord, 23, my lord. In this matter, my lord, similar matter, my lord, we have filed a counter, my lord. That was not listed, my lord. It was supposed to list along with this case, my lord.
When?
This 186/74, my lord, similar matter, my lord, we have filed a counter, my lord.
Yes, sir. Yes, Mr. We list it.
A small submission, my lord. Monday, your lordship may have it, my lord. Along with this 186/74, my lord, wherein we have filed a counter, my lord. We are adopting the counter of the same, my lord, in the present case also.
We will admit this. It requires hearing. Petition is admitted for hearing. What submission?
Small submission, my lord.
Please.
The web portal has been opened till 8th to load all certificates and everything. And immediately after that, the seat allotment process may take on. Which means once the seat allotment process takes and the GO that we have questioned.
No, what you want admission? What, I mean, interim order, what do you want?
The interim order that we seek is that the seat allotment should not be there till the time the outcome of the petition is there.
No, it shall be rather subject to outcome.
Yes, my lord.
Once
Once the seats are
petition
allotted,
is admitted for hearing, needless to state that the allotment of seats shall be subject to outcome of this writ petition.
public.
Yes. 24? Yes. Yes. Notice.
Challenge to act with that.
Issue notice.
Issue notice.
Andhra Pradesh and Telangana governments
Issue
have been
notice.
challenging.
Notice.
You are challenging Act
Notice.
2023.
Notice.
Notice has to.
Notice.
Item 23, Prabhat Chittaru.
Take steps. We are convinced you have an excellent case of
Very
merit.
matters, my lord. In the meanwhile,
No stay.
otherwise every day.
Every day, the amount deposited by will you give heard on the, you want an order on the stay today itself, heard on the prayer for interim, mark the presence, heard on the prayer of for interim relief. It is, you keep the amount deposited by him in a separate account, right? You are filed. So we are granting you, we have notice, notice on behalf of respondent is accepted by learned additional whatever. What, who are you? GP for transport, who praise fund is granted 4 weeks time to enable her to file counter or on the question of interim relief.
But this is
Learned counsel for the
Without even hearing the other side. That is why we have ordered notice, because we have read the bundle. We said, we thought it fit case to order notice. Yes, come on, next.
Notice only accepted so and so. That's
GP so and so, then 3 weeks.
4 weeks, 4 weeks.
Sir.
Yes.
This is a matter.
That flood thing, yes.
The affidavit was to be filed today, minutes.
Ah.
I'm just requesting for a day's time today.
Monday, Mr. Prabhakar. Learned, special counsel case for.
Orders of this honorable court only
Yes,
need
sir.
to be complied.
That's what
In fact,
we expect. We will see that whether or not complied
in
with.
fact, my lord.
Learned, special counsel prays for a short accommodation states that the affidavit in compliance of the order dated
Order 28/7. 28/7.
28/7. No, the detailed order we have.
1st August, 1st August.
1st August 23. 1st August 23 shall be filed. Compliance affidavit shall be filed.
Monday.
On or before, no, on by Monday. What is list on what date? Mondays or 7th August.
BP of the.
Oh, perhaps we are unnecessarily trying to hurry up and then in the process offending the learned members who feel that they are not being heard. We should only take up 21 is the batch, right? LCC, see, we have admitted, the lady lawyer was appearing, we admitted this petition bunch.
No, this is not related to the batch.
21.
He is seeking, my lord, the benefit, my lord, IAS post, my lord. This is not related to a batch.
This is
So,
that
21.
Yes, my lord. Tahsildar he
Item
wanted.
21, WP number 14557 bar 2023 be delinked from WP number 14827 bar 2023 and be listed separately for orders.
Both of you are supposed to file counters in that.
No, Lord, I would make one submission. He asked for the same relief and by approaching the Central Administrative Tribunal. The tribunal directed the government of Andhra Pradesh to pass the detailed order. My lord, accordingly, the impugned GO was passed. Therefore, he has to question that, my lord, by way of a OA before the Central Administrative Tribunal, instead of coming to this court directly.
We will separately. Separately, next week.
Yeah.
The link list next week. Will come. Fine.
Item 26 and 27.
That's 26 and 27 together. Pleadings are complete. Malets, in fact, we are in vacate. It has been so clear.
This is
after a week.
sensitive matter. FTL area you are trying to encroach upon race custom.
And they have laid a road also.
After a week, Malets, after a week.
No, date. Tell us.
14th Malets or 19th.
9th August.
Published.
Arey, Mr. Give us this thing, synopsis, to save time.
Published.
28 counter. Learned counsel for respondents.
This report has done
Ah.
regarding basic amenities to
Government college.
government girls students. So they are sensitive. We'll have to consider the report.
9th August, in compliance of the order dated 1/8/2023, respondents have submitted a fresh status report. Let the petition be listed for further orders on 9th of August 20. Yes.
File counter mallet on behalf of 5, 7 and 8 mallet.
Yes, I file counter on behalf of
5, 7, 8 you have filed.
Yes, sir.
3, 6 and 7. File counter.
Need to run from
Who files counter for
3, 6 and 7.
you have filed?
Yes, sir. Yesterday I filed.
Yesterday you filed. Learned counsel for respondent 3, 6 and 7 submit that he has filed a counter yesterday. What date? Yesterday. The office same is not on record. Office is directed to trace the same, place it on record. List on. After 1 week, some. 16th August. Let For the appellant, my lord. let the appeal be listed. 1 minute. Let the appeal be listed before a bench in which one of us write his lordship's name is not a member. Yes.
My lord. The writ petition, my lord. Two different process, my lord.
Virus you have challenged.
Yes, my lord.
Pleadings are complete.
Yes, my lord, pleadings are.
Pleadings are complete. Petition is admitted for hearing.
My lords may kindly note that the petitioner is retiring in some time.
Please file an application for urgent hearing. We have been telling everyone. Because see, you will realize that all cases cannot be heard in motion hearing, right?
Matter would not have reached us.
Counter of 5 million.
My lord, consequent to the order of this honorable court, my lord, the Telangana government passed a.
Your grievance,
Released.
all right.
After the charge assigned, that
This thing 34. Yes. All right. In this writ petition, the petitioner inter alia has prayed for the following relief. Learned
government paid for services 4 million.
in what copy? He is making a statement, right? Grievance stands redress. We are dismissing petition. Learned counsel for the petitioner submits that the grievance of the petitioner stands redressed in the light of geo dated.
That proceeding, that's why only I am giving the proceeding.
Arey, Mr.
No. Proceeding 14/3/2023 also given that drop, charges are dropped.
Stands redressed during pendency has referred to order. No, this is an order. Proceeding. Communication dated 14/3/2023 sent by the Director of Industries to the petitioner. Right? The aforesaid communication is placed on record. In view of aforesaid submission, nothing survives for adjudication in the petition. Same is disposed of. Yes.
Pleadings are complete.
Pleadings in the case are complete. The petition is admitted for hearing.
Please.
Notes for that.
Counters yet to be filed, but the respondent sought time on the earlier occasion to file counter.
Let none for respond number 5. Let counter if any be. You are appearing. You are filed.
Your lordship.
What about 5?
I am representing the respondent number 5, your lordship. We have to file a counter.
How much time you want? We don't want.
2 weeks, your lordship.
Say R5 2 weeks.
R5 2 weeks, your lordship.
Learned counsel for respond number 5 press for 2 weeks time to enable him to file counter.
Obliged. Much obliged.
After. Don't give dates.
Coming for the counter of the garment, my lord.
Yes.
All are similar, you lord. Today, ask me that time, you lord, for filing counter, you lord.
How much time?
3 weeks, you lord.
Whom you are appearing for? Again, we have to ask.
Other respondents, you lord.
Learned counsel for respondent, whatever his name, GP, whatever. Praise for is granted 4 weeks time to enable him to file counter.
Okay.
None for the petitioner. Awaiting appearance, hearing deferred. Counter.
May I please, my lord? This matter is, my lord, identical issue has already been dealt. Same proceedings between the almost same parties, except the petitioner changes, my lord, was allowed. My lord, it was allowed and relief was granted.
Which is that?
It's found at page 43, my lord. By the honorable.
Learned counsel for the petitioner submits that the issue involved in this appeal. This is single bench.
No, my lord, page 40.
Issue involved in this appeal is squarely covered by an order dated for judge order or whatever. The order dated 4/7/2023 passed in WP number 12010 of 2023.
grant of paper.
Full stop. In view of aforesaid submission, learned counsel for respondent prays for short accommodation to enable him to examine the aforesaid aspect and to file the counter if so advised. List after 3 weeks.
I'm grateful.
This matter refers to 2 weeks time to file
Learned
counter.
counsel for respondents pray for and are granted 2 weeks time to enable them to file counter. Huh. Let counter, if any, on behalf of respondents be filed within a further period or within 3 weeks.
Yeah, next.
It's coming for counter,
Let
counter is not filed.
Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
There is interim order, my lord.
Interim order granted on earlier occasion shall continue.
There is no interest.
If any will come.
If any will continue.
If any will continue.
Interim order, if any, shall continue. We said.
Interim order.
That's why I said.
That's
we
why
said
if
we-
any. 45. Yes.
Your lordship, this is a.
Learned counsel for respondents pray for and are granted 3 weeks time to enable.
Lordships finally, because this is the exact.
23 petition. And without them, nothing, we can't remove encroachment.
They are asking for.
Okay. 3 weeks, all right.
Guide your lordship.
3 weeks to file counter.
Not in this.
Well, I pray time for filing counter, millet. In this matter, we entered appearance
Which
for 18
respondent?
and 19, millet.
Learned counsel for respondents
Respond number 3, my lord.
3, 18 and 19. Pay for and are granted 3 weeks time to enable them to file counter.
Obliged, will say.
And let's, Lordship may adjourn this by 6 weeks, my lords. There is an interim order recording the, my lords, submissions by the respondents 1 and 2. This is with respect
You
to,
have filed counter.
we'll file it, my lords, after 6.
Say so. Learned count. So and so special GP. What GP?
As to the office of
Ah.
Advocate 6.
6 weeks time to enable them to file counter. Interim order, if any, granted shall continue.
Yes, next.
49.
My lord,
Yes.
this is the case for in which the members of
The process has been initiated, right?
Yes, my lord.
For filling up the post of this thing,
Yes, my lords.
chairperson and members of Telangana State Human Rights Commission.
Yes, my lords. We have initiated the process.
Then what time will you conclude?
14th August is the last date for submitting the application, my lord.
Learned counsel for respondents submit that the process for appointment to fill up the vacancy of chairperson and members of Telangana State Commission has already been initiated on
Initiated and the last date.
what date? Initiated and the last date for
14th August.
submission of applications is 14th of August 23.
Yes, my lord.
Then
My lords, it may posted anyway last week of August, my lords. That by that time we will be.
we will give you more time.
Yes.
Learned counsel for the respondents, however, prays for short accommodation to enable him to apprise this court as to within what about the time limit within which the said process initiated by the respondents would be concluded. List on
September.
11 September 23.
Deeply.
11th. 11th.
Your lordships,
Better affidavit you had to file.
yes, I have filed, my lord, on
When?
23/6/2023. I have filed on 23/6/2023.
Learned counsel for the petitioner submits that he has filed a better affidavit on 23/6/2023. Office is directed to trace the same and place it on record. When?
Lordships, convenient date. The issue is very important issue. 300 crores worth of land as given for 5 rupees, my lord. Which is against to the natural resource judgment.
28/8/23.
Items 15, 300 CP per
Which respondent? One, praise warrant is granted 3 weeks time to enable him to file counter.
Your lordship, I beg to appear, your lordships, there is an interim order to the pollution
Which
control.
case?
My lord, in this matter, appearing for respondent 4 and 5, my lord. In this matter, report has been filed, my lord. We're seeking a
Have you supplied a copy?
No report has been
Correct
come.
counsel for respondent number 4 and 5 undertakes to supply copy of report dated
My lord, report dated 25/7/2023, my lord.
25/7/2023 to who appears with you, madam? Write his so and so learned counsel within
Will submit now, my lord.
during the course of the day. Learned senior counsel prays for short accommodation to enable her to go through the same and to make submissions.
Your lordships, pursuant to the order, your lordships, they were supposed to close, your lordships. However, the hot mix plant in that area is still running.
We don't know. I mean, you see what is the report. We'll fix a date.
Your lordships may fix an early date.
Yes.
Your lordship,
1 minute, earliest we have 22nd August.
My lordship, I am appearing for in this matter, my lordship. Respondent number 30, we filed to counter, my lordship.
File it, nobody prevents.
with the lordship permission.
This is a matter, my lord, which has taken up so motor.
Custodial death, serious issue, Mr. No counter.
Counters have been filed, not counter. Filed.
What is it?
But the Advocate General would like to appear in the matter. Lordship.
Learned so and so submits that the learned Advocate General would address this court. Fourth September 23.
Okay, thank you.
It is coming for, lordship may have to fix a date for hearing because validity of.
These are all covered, right? It is no longer a Sintigra. You have challenged an order, you are petitioner.
Yes.
You have challenged the gift deed, the Assistant Commissioner under 2007 Act has declared the sale deed as void as the maintenance was not provided. So
Validity
instead of adjudicating, we would very much like that you sort it out. It's a dispute between parents and you. You are son or daughter? Son. Right.
Fighting against parent.
You would do well to advise them not to call upon us to take a decision, or we will ask them to appear before us if you so.
Already that was done, madam. Even that was done. And that is also.
Why should you not tell us? We'll forget about law. Tell us why should you not take care of your children?
I am taking care.
Fine.
Your lordship, sir.
12th September. Counter.
Counters already filed.
Filed?
Yes, I have.
So counter file.
Should. Can some time replace there, I'll file.
Learned counsel for the petitioner submits that he has received the copies of counters filed on behalf of respondents. He prays for and is granted 2 weeks time to enable him to go through the same and to file a rejoinder if so advised. All. Now, medical admission.
Next one also similar.
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 Connected.
Much of motion. Lunch motion.
Sorry, I mean, we have been in a hurry, so bar should not get an impression that we are not hearing. Nothing of that sort. We wanted to this thing. That's why, right? Next week onwards, we hope that things would fall in line. I mean, everything would be.
Other cases on board, my lord. Because Supreme Court remanded matters. That's why, my lord, your lordship may have the 10th of next week, 10th. 18th, they filed the petitions. 59, 60.
10th August.
10th of.
So
59
to 63.
Yes, sir.
List on 10th August 23. Huh? There's no 64 here. In our list.
For hearing, there's an advance. Madam, this is advanced. For hearing matters, we'll give a date.
And date.
Yes, lunch motion.
We have some lunch motion. Thereafter, please wait if you want a date in final hearing, please wait after lunch motion. Yes. What?
May I please lordships? May I please lordships?
You are smiling, that means you are
Please to hear item number 58. My lord, your lordship may please to defer hearing for any day next week. Item number 58.
No.
58, we'll give a date, Mr. Additional Advocate General, we'll give a date afterwards.
Pleasure, my lord.
No, this 1 minute, wait, we are hearing this. We thought lunch motion, we thought that you are saying that grant interim relief to the petitioner, that's why you are smiling. So, yes. What is the?
May I please lordship? Petitioner appeared for the NEET examination and he was qualified, lordships. What has happened, lordships, in this case? Page 40.
NEET UG exam.
That's NEET UG undergraduate. Was qualified, lordships. Now they've given a merit list, lordships, at page 41. And in the merit list of page 42, lordship, your lordship states that he was not eligible for MBBS and eligible for PDS. Lordship, page 42, your lordship states that serial number 7400 is a petition not eligible for MBBS, eligible for PDS. The ground, the lordship, that is, lordship, in 2021-2022, the petitioner appeared for the NEET examination.
No, so you are saying that you should be admitted against MBBS course.
Yes, lordship. They rejected me on the ground, they treated me as ineligibility on the ground that I appeared for NEET examination 21-22. I did not join the college. So I am treated as ineligible as per the GO, lordships. GO 114. The ruling is at
appeared for NEET 21-22.
21-22, lordship. Even I got a rank for in a B category. I did not join the college.
So in this you are being treated as ineligible because you appeared 21-22.
I did not join because I did not join.
Acha, though got a seat, did not join.
Did not join. Lordship, the ground there, page 20 is the ground, lordships. Page 20 is the GO. 21.
20.
Page 20, lordships. The GO starts from page 14, but the page 20 the selection committee, rule 7, selection procedure 4, surplus 17, lordship. And the 21, lordship, your lordship takes it. 21, para 2. The candidates who are selected for admission into MBBS courses.
Which para?
Second paragraph. Page 21, second paragraph.
Yes.
The candidates who are selected for admission into MBBS previous courses, including cited candidates who have joined in the previous round have to report the admission without fail. Otherwise, all these candidates, such as will be debarred for 3 years for admission into MBBS PDS courses in the state of Telangana. Taking that into consideration, lordships, I was treated as ineligibility.
You are challenging this in this petition.
Lordship, for the petitioner. Lordship, earlier
you are challenging this clause in the petition, right? This provision.
Lordship, what has happened, lordship? Earlier, lordships, in 2020, earlier year, last year also similar thing has happened. Writ petition has been filed for several writ petitioners. Lordship, this honorable court has considered and permitted them to take the course. The order you are not dated page 61.
Permitted them to this
participate in
counseling despite this provision. It was not struck down. What is the GO dated?
Lordship, GO is dated to 5/7/2017, lordships.
All right. What is the division bench decision?
Lordship, page 61, lordship, lordship gets the operative portion at page 75, lordships. Debarring a student for 3 long years for pursuing MBBS BS would be too harsh punishment. thereby depriving their right guaranteed in Article 25 of Constitution. All the students who are aged between 70 cannot be expected to know the intricacies of legal.
Let I can
So you want this,
the SLP is filed before the Honorable Supreme Court, which is coming up on 7th, my lord, next.
not 7th?
On 7th of this month, my lord. They have received notices. Petitioners there too. I have received notices from the Honorable Supreme Court, but they have not chosen to be present.
Correct.
Ultimately, these matters are coming up before the Honorable Supreme Court on 7th of this month, my lord. Here, your lordship were kind enough to pose a question to them whether they have challenged the rules or not. In these matters before your lordship, the rule, where constitutional validity or any statutory validity have not been challenged before this Honorable Court, my lord, unless the rules are not challenged. Much.
Every time need not be challenged. Once this court has already held that rule to be virus, ultra virus. Not every time they need to challenge.
Yes, earlier point of also, my lord.
They will amend it. Amend.
My lord.
In this writ petition, I have not, but in writ petition.
So why you did not challenge? You should have filed an application for amendment during the course of the day. Arey, Mr. File it.
I filed it.
We are talking about 20990. You are, no, you 20990.
I have not challenged.
Shall we, you want us to dismiss the petition?
No, I'll make it 6 steps.
On our own, we are telling you that file it, you are saying that I have challenged. So challenging in other writ petition, that petitioner will get the relief, you will not get relief.
Take steps for amendment. So, I'll take steps for amendment.
All right. So when is the counseling held?
The web options from today morning to tomorrow evening 6 o'clock.
Counseling has commenced today.
No, web options. We need to opt the web options for colleges.
They need to submit the colleges.
Web option. Commenced until tomorrow. What time?
Till 6 o'clock tomorrow evening.
Sunday we were told in some case.
No, lordships. Web options is from 6 a.m. 4/8 to 6 p.m. 6/8.
6/8.
Today, tomorrow or up to Sunday?
Sunday, 6 Sunday.
6th is Sunday. Today is 4th.
Then why? Where are you, Mr.? All right. Except notice, we are granting an interim order.
Yes. My lordship.
Understood your defenses against order passed by division bench, especially petition as preferred fixed for 7/8/23.
I would like to make one thing.
Is there any stay?
My Lord Justice Vinod Kumar, please to posed a question. Well, even in the earlier writ petitions also, the validity of the rules were not under challenge. My Lord, as of now,
you heard him saying that he will make an application for amendment today.
Subject to lordship, let him make a petition to amend the relief. And
let him permit not to exercise the web option, right? So that he misses the bus by mistake of the council.
I would like to make it clear, my lord.
Why you should be in these matters, Mr.
Seats?
We have understood your submission that two things, that he has not challenged the validity of Geo, therefore no relief can be granted. Secondly, that the matter is coming up before Honorable Supreme Court on 7/8. Understood, right? Not that difficult. Why you should be callous like this, Mr. Counsel? This extremely especially in the matter of students, their future is at stake. You should be so. What happens if a doctor performs a surgery on you with this much of negligence? You will be here standing. Please, you are a professional. We urge you to be more cautious.
I'll take steps, immediate steps.
And tomorrow we plan to information also same order. Today and tomorrow. So we are recording is undertaking that we will.
That in the state. Just your lordship may please to take it to judicial notice, my lord. There is an important issue. My duty is to bring to your lordship.
Yes.
There is a big racket had been going on in the state. The reason is the scandal, my lord, I can say it. These people will not report for admission, and ultimately the seats go to. Why they will reported? My lord, these seats will next matter is scandal.
Mr. Senior Counsel, we are not deciding this petition finally. This all scandal and all this.
Web
option.
We will continue.
And you file and your objections at the earliest possible. Tell us We are not allowing the writ petition. Let him indicate where we are, Mr. I is speaking for myself, has an occasion to deal with such a scam in state of Madhya Pradesh, that is famously known Vyapam scam. I is sitting with my Chief Justice, Honorable Justice Khanwilkar, as his lordship was. I delivered the judgment being a member of bench, cancelling 600 admissions to MBBS course upheld by Honorable Supreme Court, right? So we know, so we are aware about such a this thing that there were new dimensions in Vyapam to, you are only confining that these people appear and leave the seats for others.
Yeah. Yes.
So they don't take admission.
Genuine merited candidates are
No,
private.
no, since he has come before us, so we will see that if he is eligible, he gets admission. And doesn't offer it to anybody else. This thing, the court will ensure that scam, at least in this case, doesn't take place. He doesn't walk out.
What my lords, AG is saying, not restricted.
No, you undertake to get admitted, right? You will not leave the seat if it is offered to you on the basis of merit.
How we need to pay 20 lakhs if we leave the seat? That petitioners cannot afford for that.
All right.
That is the bond we have.
Mark the presence. Heard on the question of admission and interim relief. Learned counsel for the petitioner undertakes to file an application seeking amendment of the prayer challenging the GO dated 5/7/2017 during the course of the day. Bearing in mind the salutary principle that for the inadvertence on the part of the council, a party should not suffer, we are inclined to grant him the liberty in the peculiar facts of the case. Paragraph. We have heard learned counsel for the parties at length. The petitioner had appeared. The petitioner had appeared in the NEET UG examination and has qualified the same and has been held entitled to participate in the counseling for admission to BDS course. Full stop. However, the petitioner has been declared ineligible to participate in the counseling on the ground that he had participated. He was declared successful for NEET examination 2021-2022 also, and though was offered a seat, did not the petitioner did not take admission. Full stop. The petitioner has been declared ineligible in the light of stipulation contained in the government order dated 5/7/2027, by which such candidates are held ineligible for admission for a period of 3 years. Paragraph. It is brought to our notice that such a stipulation, the impact and effect of such a stipulation in the previous GO was considered by a division bench of this court, and the division bench of this court by an order dated 16/11/2022 had held that don't fold hands, right? Why? Ask who is your client. Don't tell, the order is being dictated. Other case. Sit down. A similar impact of a similar stipulation. Such a, instead of such You are appearing for the university, right? So,
I'm instructed to appear.
yes, fine.
Let them inform, so
Yes,
that.
we will.
All cases same, all cases same,
No, I kept by 6.
3 to 6, okay.
What made this petition file challenge?
No, so we,
Number
two is
72.
different.
One,
One.
1, 3 to 6.
1, 3 to 6, same order, right?
Morning
Oh, you
collection
sent
by
someone,
cost.
don't stand here. You have to type matter pertaining to student. What is the urgency, Mr.?
This petition challenges the GO number 72, that is page 14, Milord, restricting restricting the 100% seats to the Telangana state only. GO.
Morning,
Morning we passed an order. Who took the order? Which item, Mr. Please tell us. Item 3.
Yeah.
Same order in item 3, right? You know the order.
I have seen with
So then you should have
I have seen, I have easier.
what was the most effective argument just in a second? Same order is in item number 3. Huh? You are saying GO number, we don't know which GO number.
So and so takes.
Worship, I would have 9-8.
9-8 minutes, batch is coming.
989. Same order.
5 to 2.
The only urgency is that when the PR.
Sir, we have given some time, no adverse order. It's a PIL. We have given some date. Mister, we are not sitting here to, you will be absent and then we should sit and explain what order has been passed. If it is adverse to you, open to SLP, I'll go through that order, modification, whatever listing. We don't know. We are sure we have not dismissed the PIL and we don't need your assistance now because it's a cost taken up by the court. You don't have a locus, Sheila Barse. Don't fight it as a personal interest litigation. Mister, one thing we say, one thing we have been telling everyone that you owe a duty being an officer of the court to be fair to the court all times. Number 2, you should owe a duty to the court to be reasonable at all times. We are also human beings. See the time. See the time. No. And then despite that, you are holding the court back for just for your convenience because you were absent. No. So shall we ask you file an affidavit? Why were you absent when the case was called? We will deal with it. It's our cause, Mister. We don't need your assistance. Thank you. Thank you. We don't. Then you want us to alter an order which we have already passed, correct? File an application for modification. This not done in any court where it should not be done. Even if an erroneous order is passed, you file an application. Nobody prevents you from modification. If it's according to you so absurd, file SLP. Supreme Court will set aside.
Sorry for holding it.
What order has been passed according to you?
Time might have been granted. Counterbalance, maybe for counterbalance.
So the whole thing is to know from the court what order has been passed, right? Yes, madam. Please tell why to this thing. Good, right? All these facilities, if we would have been available when we both were practicing, then probably we would not have accepted this assignment. Judges were very tough in the times when I have appeared. I could not have dared to hold the division bench and ask what order has been passed. No, this is what it is. And simply saying, know the order and say, I apologize. You want to know the order, right? Huh? Not saying anything beyond this, apologize, this thing matter. What do you want? What is the order, madam? Adjourned by 3 weeks. No, this thing. No adverse order has been passed. So you wanted to know how much time it has been adjourned, right? Don't be reasonable. We have to sign the order which we have just, student is involved. No, saying apologizing and holding the court back, not good, right? Sit down. All right, what is public interest? What is public interest in? Speak into the mic. I mean, first difficulties we are unable to hear.
Milods, the notification dated Milods 8/5 calling for bids will be finalized by 7th on this month, Milods. It is regarding establishment of Aqua Marine Park at Kotwalguda. Thereafter, notice has been issued after admitting the PIL. The finalizing of the bids is on 7th.
No. So you want us to allow the petition today?
No, Milods, that's not.
The counter is awaited.
Milods.
We have granted time to file.
Yes, Milods. Yes, Milods. The call for a bids is the finalizing on Monday.
What is he arguing? I mean, I really don't understand.
Without counter, without knowing what they are doing, can appeal be ordered?
No, Milods, I am only seeking regarding the last date of finalization of the bids, which is 7th of this month, Milods.
What happens even if it is finalized?
Milods, thereafter third party's interest will also be created, Milods.
They know that bill is pending.
Yes, Milods.
That is the end of
Very
the
well.
matter.
Very well, Milods. I bow down once again, Milods. I am apologizing to your lordships. I would not commit. It's a lesson for me, Milods. I apologize.
When a bill is taken note or taken cognizance by the court, everybody knows that there is a matter under consideration by the High Court.
Milods.
So if any adverse, they do actions contrary to the what is under consideration, they will face the consequences. Why are you bothered?
Grateful to your
You have brought to the notice of the court, that's the end of the matter.
So you are at the instance of the person who is not going to get a bid. So you want to stay in this PIL.
We are not at all, Milods. I bow down.
We understand, Mr. All of us understand.
I bow down.
So in addition, what as officers of the court, you have to be fair to the court at all times and be reasonable to the court.
Very well, Milods.
We don't want to write about your conduct that after this thing, court was hearing at 1:55, the council knew from the court, wanted to know from the court what orders the court had passed, and thereafter made submission in the absence of counsel for respondents. Supposing if we record all this, what happens to your future? Be reasonable, you are a young man. Supposing if we record everything, then what happens? What will be your impression? This is not a public interest litigation. That itself shows, your anxiety itself shows it's not a genuine public interest litigation.
I apologize.
You are here at the instance of the sponsored, some sponsorer has placed you there. That's why. And we don't need your assistance. It's not a personal cause, right?
No,
we have taken note of, we can order that we can appoint senior counsel sitting there as amicus. Yes, we don't want your assistance. Thank you. For being, supposing if we write all this and pass an order in view of Sheila Barse, what would happen?
Adverts to
Don't, Mr. We are telling you, this is only a case, right? Don't put your future before the bench for a sake of case. Right? This brother would be watching your conduct. Henceforth, you appear before him in any other case, he will say he is a person who is not reasonable.
That had not been the case. I am only putting forth, Milods. It's not a personal interest. I bow down and I sincerely apologize to your lordships, Milods.
Why we are spending our energy on you is in the fond hope that you will receive it in correct perspective and improve.
Yes.
Looks like. Otherwise, we would not have said, we would have kept quiet.
I'm grateful to your lordship.
If you are beyond this thing, repair, we would not have even wasted so much of energy. So with your permission, can we now rise for the day? With your permission, finally, at 2 o'clock, can we rise?
I'm grateful to your lordships.
This item number 81. Counsel for the petitioner has sought for a 1 week time to file a reply. Must may have it after 1 week.
81. Why do you want time?
The report has been filed by the receiver. They want to file an objection to the.
Ah, yes, yes.
For that.
81. What's your name?
Pranay Sohini.
Learned counsel for the, this is what we appeal, learned counsel for the appellant. Applicant. Grace furnace granted. How much time, Mr.? 2 weeks.
2 weeks.
2 weeks time to enable him to file objections to the report submitted by the commissioner. Yes. This was 81, right? Mr. This was 81.
81.
Okay.
92 to 97, I'm appearing for the appellants. I request 4 weeks time, my lord. Matter is seized off by the Honorable Supreme Court and there is a stay in this matter. I have already informed. Yes.
Where is that?
That's already part of the report, my lord. I have
92 to
97, my lord.
Please. Which order?
The very same final degree that I am challenging in this matter was challenged by the government before the Honorable Supreme Court. Now, the Honorable Supreme Court has granted stay of all further proceedings, my lord. And this is
92 to 97.
97.
Right. Which final decree have you challenged in this?
My shares were purchased, my lord, by the respondent number 1 in the OSA, my lord, under an unregistered assignment deed. And challenging the same, I filed OSA. And government carried the matter in appeal, my lord, before the Supreme
You
Court.
want to record your statement, final decree dated?
Final degree. Answer. Final degree in application number 1146 of 2002 dated 9/10/1409 of 2000. Application number 1409.
What we understand that from in 92 to 97, this a division bench passed some orders which you assailed before Supreme Court. Correct?
No, the government has taken the matter to the Supreme Government. My lord.
Which order was assailed?
My lord, it is in application number 1409 of 2003.
27/4/2022, right?
26/12/2003, my lord.
Array, Mr. Page.
Batch matters. That is, my lord, there are certain facts necessary to mention. My lord, take it when it reaches, my lord, I'll explain, my lord.
Huh?
When it reaches, my lord, I'll explain, my lord, the facts.
Better.
Better. I apologize.
83 to 85, my lord.
It will be called.
Objection.
It will be called. Please do not. Please stop this out of mention. We are all everybody. This thing we will take it up. Yes. It will reach. Don't worry. No. Yes. Item 82. 80. Yes. Yes, madam.
Lordship, kindly post the OSA numbers 18 to 25 of 2004 and OSA numbers 31 to 34 of 2011. Your Lordship, next week, Your Lordship. The division bench rendered difference of opinion, Your Lordship.
You have to file objections to the report of the commissioner, correct, madam?
Something else, my lord.
No, Your Lordship.
Yes.
Something else, my lord, she is talking about.
No, Your Lordship. Mentions.
Respondents had to file counter to the review petitions, right? Sorry. 1 minute. 4/1/2022.
Next page, sir. Yes. Challenged.
Yes. Matter is pending.
I am appearing, may I please, I am appearing for IA 1 to IA 6, my lord. In IA 5, we have filed recall petition which was allowed, against which SLP was preferred before the Supreme Court. And that SLP was dismissed, and then against which that was allowed, and we have filed review in that. And the review is pending, my lord. It has been heard on 18/7. Now we are awaiting for the next date of hearing or the result.
Heard on 18/7/23, madam.
It was listed.
All right. So matter is pending before Supreme Court, madam. So then we should await, no? She's saying that 18/7.
Yes, yes. 18/7 it was heard last.
All right, yes. Learned senior counsel
Lordships may
for
kind-
which respondent?
I am for up in IA number 1 to 5.
Their presence right is stated at the bar that against the order dated 23/8/2022 passed by Supreme Court in Civil Appeal number 5784/2022, a review petition has been filed.
Yes,
Huh?
yes, my lords.
What is the number, like, if you could give?
1333, my lords.
1333
Of 23.
1333 of 2022, in which arguments have been heard on 18/7/2023.
Yes.
What it is reserved for orders?
Next date is not given, my lords. We
Right.
have to await.
Learned counsel for the parties pray for and are granted 4 weeks time
Obliged.
to enable them to apprise this court with regard to the order which may be passed in the aforesaid review petition.
And we also need to obtain the commissioner's report here, and we should file objections also.
Needless to state that the party shall also be at liberty after 4 weeks. Before that you write out, madam. This court by an order dated 23/3/2023. Nobody is appearing. So we have said what to do.
Bring them within 90 days.
Right.
90 days. The nice protest and living and it will be due to the action. That's why I should make conditional property. In the being ready to be interact.
Who has typed this? Petitioners or petitioner? There is only one. On the cases, Mr. Only one case we had dictated the order, same order in the other case. In remaining cases, they have challenged the validity. You have passed a common order, right? Council. We will see the same information. You call the number, Mr. Don't wait.
Lordship, may I please, Lordship, proof, file objection to the receiver report, my lord, kindly post after 4 weeks.
Which case? 83?
83 to 85, lords.
83 to 85, learned counsel for the petitioner.
File objection to the receiver.
Case fund is granted 4 weeks time to enable him to file objections to the report submitted by the commissioner appointed by this court. List there are 83 to 85.
This will say, this is the only expression, including the variable list of the things. This is for one classification, is the last thing. Just the application itself is dismissed. Who is the applicant?
I've given up on that. In my fixed system, I mean, that's the next stop.
Now, is there any representation now? Because earlier on last occasion, this application was dismissed for non-prosecution. Again, it is listed today.
And I will try the all these applications.
How many are there?
There are
You have modified the order.
86 to 91.
I told you to pass one order in one case. This is not the dictation given. You have made it modified. You have modified it according to. We said that he has been qualified to. He has been declared successful for BDS course. You did not write all this, Mister, and you have made it just to save your time. Common order. Did we dictate the common order? Same order. There should be different orders. Don't make it. Whatever I had dictated, I am correcting it. You make it a order pass in one case only. Don't do this. Give us one moment, counsel, please. One moment. Yes. Take a different print out in every case. Bring it here immediately after carrying out corrections. Yes, please. Why it is listed? Then in the value installation, you have taken the present application is non-dictionary is state of the voice application or installation. Yes. It is IA 1 2. None for the petitioner. What's your name? Mr. Janardhan Reddy, Learned Counsel for Respondent. It appears that the applicant is not interested in prosecuting IA 1 of 23. '87, '88. '89, 1990 already dismissed. Yes. Or what happened to 89, 90, 89? Hi, you didn't call 89.
91.
Huh?
Up to 91. Item number 91 up to.
Up to 91, it has to be dismissed, right? All right. Same order up to madam 91. Okay. Yes. Yes.
Wait, please, Your Lordship. Lord, I have requested for 4 weeks' time on the ground, my Lord, that we want to wait not for the verdict of the Honorable Supreme Court in the SLPs, the orders of which I have passed on. The connection is like this. OSA number 5, I filed challenging, my Lord, the final degree passed by this court.
You want to say that issue involved in these,
Yes, in this appeal, my Lord, directly involved, my Lord, because of, before the Honorable Supreme
which or SLP?
My Lord, Your Lordship, I have just passed on 2 order copies.
Where is that? Where?
Lord, during the call work, I passed on 2 copies. Your Lordship wanted to see the stay order.
Where is that, Mr.? Order, Supreme Court. Oh, this one.
Yes.
Yeah, is this.
This is the SSB, my Lord, preferred by the government.
Learned counsel for the appellants, while inviting the attention of this court to order dated 14/3/2023 passed by a division bench of this court submits that the aforesaid special leave petition is still pending before Honorable the Supreme Court. He therefore in SLP number so and so, please see from 14/3/2023 order, but this is written. SLP number 19647-19648 of 2022 and 19748-19749 of 2022. In relation to the same property. Full stop. In view of aforesaid submission, hearing is deferred. List after 6 weeks.
Obliged.
92 to, Acha, you can file objections if you so want. To Commissioner's report.
But I have not yet filed, I take 6 time.
That's what we are saying, that you can file.
I will.
Line below, before, after list after 6 weeks, before that you write an order. Needless to state that the party shall be at liberty to obtain the report of the commissioner from the registry of this court and to file objections if so advised on or before next date of hearing. List after 6 weeks.
Obliged.
92 to 97.
92 to 97.
In this matter, my Lord, torture challenge before the Honorable Supreme Court, my Lord, in SLP 12320/23. Matter is coming up on 18th, my Lords.
SLP number
12320 of 23.
12320
of 23.
23.
Coming up on 18th.
Against which order you have filed?
This granting of status order by some.
What is the date of order? In this case, order was granted.
4/5/23. Vacation code. 4/5/23.
4593.
2023, my Lords.
All right. Learned counsel. What status quo has Meanwhile, respondents are directed to maintain status quo till next date of hearing. Instead of, you could do well to argue this matter instead of.
If we are not met parties, we filed impli. Then again that will not, in the meanwhile, the parties went to Supreme Court. The Supreme Court is taking it up on 18-8 minutes. SLP number.
Learned counsel for the applicant submits that against an order dated 4/5/2023, comma, directing the parties to maintain status quo, comma, the applicants have filed SLP number 12320/2023, which shall come up for hearing before Honorable Supreme Court on what date? 18/8/2023. Learned counsel for the applicants therefore prays for adjournment list after 4 weeks.
For the respondent only 5 and 6.
You are for 5 and 6.
And for the petitioner, he is for the.
Acha, so, but he is making a submission. So instead of applicant, you say 5 and 6.
They have to back up it.
Yes, Mr.
And for the respondent.
Presentation. Yes. We can show this. Yes. Yes. All right, learned senior counsel. All right. What's your name, Mr. So and so submits that the arguing counsel is not available. He therefore prays for adjournment list after 2 weeks. You find out, Mr. Watts is aggrieved by your inaction. So your inaction gives rise to a lot of litigation that you have been seeing, right? So Pollution Control Board, you, and then Human Rights Commission and Lokayukt are overactive. So there, this thing also gives rise to. Better deal with. See, you have seen what is the prayer in the petition. See, what is it? I mean, you seek instructions and make a statement on the next date when it comes up after 2 weeks.
Yes, correct.
Don't wait for us to issue notice and then you will find out what is it. At least you can decide his claim. We don't know what is it. Yes. Right up. 99. 100. Yes.
This final the prayer that the respondent number 1, who is the chief commissioner,
Not releasing.
he has not released the properties. Subsequent when orders passed by Honorable Court, my lord.
Subject matter is pending for adjudication.
Original owner, oh, you are a successor. What is this? What is this thing material to show that you are the successor in interest of this owner?
Yes, my lord, what has happened is, my lord, this matter is already pending for CCL. Matter is already pending for CCL and there is one order passed to this Honorable Court, which is at page number 265. 265. To the direct dispose of our application. Page number 265.
So whose application?
The application which was pending for respondent number 1.
No, whose application pending?
Filed by the LRs of the original owner, whose land was taken in the custody of Court Boards. When this matter has come up, my lord, they will express direction to the Honorable Court to dispose of the application. When the matter was submitted for the respondent number 1, my lord, the second application which was also pending to the Honorable High Court, with respect to title of the property.
Then since it has raised the application statement, title is pending. It has not handled the particular title to decide. The title will also be clarified by the Honorable High Court, my lord, where it has been explicitly stated that matter is under subject of court of law. I submitted my application on 15/5/2023, bringing this to the notice of the Honorable the CCIA, take appropriate action. They have not taken any action. That has been this ground come before this Honorable Court, madam.
As property pertains to Rayadurg Manors, connected to item number 92 to 96 Manors, today's list Manors, it is pending adjudication before Honorable Supreme Court Manors.
So that is, so brother points out that the property which is of which you are seeking an exclusion is part of CS 7 of 1958.
Yes, my lord. The point, my lord, I am getting to that also, my lord. Here, the report which has been filed has categorically stated that this property, especially the 7 of 46, was excluded.
No, Mr. You understand that serious questions arise for consideration in this civil suit, right? CS 7 of 58. And you want a part of it, just part of subject matter to be decided in a particular way. We don't know what way, whose favor. Huh? So subject matter of the suit itself will disappear, supposing if you get title. A good way to file a petition, these people should have drawn inspiration from you. Instead of filing a suit in the year 58, they should have filed a petition like you, seeking a declaration release property.
Filing as condition states from 1978, my lord.
No.
This was second appeal. I have
No, this is, no, we will not discuss this.
Honorable Court to that effect, my lord.
What is the extent you want to delete from CS 7? Please see your prayer.
Yes, my lord. Prayer number
Entire extent of 84 acres you want to delete from CS. On what basis? On what basis?
I think the judgment.
What is the relief claimed in CS 7?
My lord, there's a list of-
Prayer clause.
That's the only submission I would have tried to make.
No, you understand our query, right?
So the CS 7 is still as subject matter and final decree is not passed. This property is part and parcel of CS 7. Please hold. Now your application, what you filed is you want to exclude this property from CS 7. Then what remains? See, you want to exclude one of the entire property, the schedule, which is a part and parcel of CS. It's under a compromise degree. If that is excluded, then there is no need to grant final degree proceedings. You have to wait for the report. If you have any objections, you file objections.
CS7 would have considered where the category stated this property is not past scheduled properties in the CS7 manner.
You show us how it is does not form.
Page number 147 of my paper book. But this was the second appeal which arose out of the main suit.
You file objections to the report. We will keep it pending. Right?
Was in the report. Yeah, I'll do that. I'll take that. Because
All right. Mark his presence by means of the IA interlocutory application, the petitioner. You understand? It has been deferred. We are not dismissing you.
Matter I request one week, Milan, on behalf of Jivilla Church.
Learn it. One
objection.
A report has come, Mr. You file objection.
I file objection.
Learned counsel for the petitioner praise fund is granted 4 weeks time to enable him to file same order. Reports, this thing, report of the commissioner.
I think for the applicants of this case, you will have three applications that have been filed by HMD. Declaring the order passed at page number 14 minutes as null and void because these orders were.
The petition is pending since when 2010.
Yes.
What is it?
Sir,
Who appears?
now I request the sample court to look into the fact that these petitions are not maintainable for the reason in view of the full bench judgment of the Supreme Court, where no application is maintainable under section 151 CPC. No application is maintainable under section 151 CPC to declare a particular decree passed by the original jurisdiction under original jurisdiction. That's they have to necessarily file an appeal against.
What? Declare a decree as what?
Null and void. Null and void.
That you didn't say.
Sorry, I'm sorry.
Okay.
Null and void.
Which judgment?
Last time also I furnished copies.
No, tell us the citation. We'll get the copy. What citation?
Citation is not reported, but
not
may pass.
He is entitled to at least a copy if it's. We don't think any decision of Supreme Court won't be reported.
I will pass on the.
Everything is reportable, right?
In fact, the similar applications are dismissed. I am told my instructing counsel that similar applications are dismissed.
Salutary, not statutory. Salutary. You are a statutory principle. There is no statutory principle that party should be punished for this thing. Should not be salutary. SALU.
May pass on if your lordship so please.
Yes.
He knows the last occasion I gave him. I give him a copy in last occasion. May I pass? In fact,
time can't be granted for this thing. Like you should.
Para 24 onwards, millers. Para 24 onwards. Say full bench judgment of justice.
Full bench. 3 judge bench.
Three judge bench. Para 24. Para 24. Para 24 on.
1 minute. It can't be that it is not reported. Non-reportable. Oh. You must supply him a copy, Mr.
Last occasion I supplied one copy. I have given.
Yes. Then.
Mutual aided cooperative society versus.
Para 24 onwards.
No, this is the ground urge.
Yes, ma'am.
Para 24 is not the ratio. It is a submission made.
No, next para 24 onwards, millers. Onwards.
You will not tell us the paragraph. We have to find out.
Sorry.
Achha, you don't have copy.
Yes, I have.
Yes. You share your copy with him so that he is unable to point out which paragraph.
Right.
Para 35.
Yes. Therefore, we are.
Page 23. Before 22 space. Actually, it is going to party. Because of the other matter.
Say, it appears it is important. But it's.
Tell him, brother.
Yes, Special Counsel, what is your case?
My lords, may I say?
1 minute.
Lordship may kindly take up page 14, my lords, that's the impugned order.
So only one order.
Application 1110 of 2010. Lordship, page 14. Lordship, the order is at page 15, my lords. I may be permitted to read. Since the entire village, Miapur village, is a self-purchased property of Srimati Rahimanasa Begum, who so and so, in view of the fact the said village has been included in Schedule A of the decree passed in CS 7 of 1958. An assignment in favor of the respondents here has already been recognized in application number so and so. There cannot be any impediment in implementing the petitions and recognizing the assignment in extent of 41 acres, 26 quintas in mutation and delivery of position in favor of present petition. Now, my lordship, this is arising out of an application. Yes.
Yes, please. Now,
Para 15, I just.
What did you say for, please?
Yes. Para 15, it says.
No, what did you say in the beginning when?
The petitioner has filed 3 applications. Arising out of 3 applications, orders that were passed. Agreed saying that the HMC.
No, did you, this thing as contended by council, that did you file an application under 151 seeking a recall of a decree?
Yes. No, I asked for cancellation of an order, which is at page number 14, Manoj. Lordship may kindly see.
Which order?
Page 14.
No, tell us which order.
There are three applicants that were filed. One for mutation, one for impleading, and the other for recognizing the assignment decree. Page 14.
What is senior counsel said it's a reported judgment? Which one? Reported, he said no. What is, get this 2022 CC. Yes.
Page 14. I'll just read the applications. Appeal 1096 for impleading, 1097 for mutation, 1098 for recognizing assignment decrees in the favor of the petitioners. Now, in this, my lordship, here in these applications, HMDA was a necessary party, my lordship, and hence it was passed without impleading HMDA, and it is henceforth null and void, my lordship. And also for the fact that lordship will see page 15 once your lordship, 15 page. I'll just read. Since the entire Miapur village is a self-purchased property of Srimati Rahimanasa Begum, and in view of the fact the said village has been included in Schedule A of the decree in CS 7 of 1958, the assignment decree in favor of the respondent here it has already been recognized. Application number so there cannot be any impediment. Now, my lordship, this is arising out of an application 214 of 2000 filed in CS 7 of 1958. The Honorable Division Bench of this Honorable Court has passed an order. Lordship, I kindly take page number 27 once. The order starts, and Lordship, may kindly go to para 44.
Without hearing. Actually, nobody appears, just only receiver, they have ordered and also paid me 50. This is a bad work. So there is lands which.
My case in a nutshell is, my lordship.
Government specifically, they have not been heard before this office.
Lordship, page 44. Unnumbered para 3. That on 8/3/2000.
1 minute.
I'm sorry.
Yes, Mr. You should file counter, right?
And also about the delay also, let's say 2002 orders, they charged it in the 2010.
No, but that order has been passed without hearing them.
No, they see.
That's the case.
No, they are not.
They have been heard. That-
Now,
That's the cases.
what their case is, without they
Come to page 15, Mr. 15, 1-5.
they released that they were not heard, but they were not party to the proceedings. If at all they have any grievance
That's
against
what they say. That's what they say. That
No, I'm on the point. If at all they are aggrieved by the order, they have to seek leave of the court to file an appeal against that order. Not under 151 CT. Anyway, I will file my counter.
How much time?
2 weeks, minutes.
Learned counsel for respondent praise furnace granted. This was 102. Same, 104. So 105 now. 105? 103 same. Same, no?
All 105. But it's in the next time, I file objections for that report of the receiver. Not 2 weeks. after
Learned
that
counsel
grant.
for the applicant praise furnace granted 4 weeks time to enable him to file objections to the report submitted by the commissioner appointed by this board. List thereafter. Same, 106.
Lord, filing objections. In this case.
You want to file? Huh?
Receiver.
Same order matter.
Your Lordship, I'm representing Respondent Counsel Butla Venkateshwar Rao. Your Lordship may kindly grant 2 weeks time to file counter in this matter.
I won't object that.
Learned counsel for respondent praise furnace granted 2 weeks time to enable her to file counter.
Much obliged, Your Lordship.
So last date, madam, this thing we had awaited the report submitted by the receiver. Now the report has come. No, you are which party in this? You defendant 5 in civil suit in OS 7. Yes. 7 of 58. So you filed an application seeking your substitution. So it must be accompanied by some sort of a this thing. No, we have to conduct a summary inquiry before ordering your substitution. So what is the stand of this thing? Others, they are not opposing your prayer? No, we are, whether plaintiff is opposing the prayer for your substitution, we are asking you. No, notice has been issued of this thing to others. Yeah.
Yes, madam. From defendant number 5, 5C. Where do we get that 5C? Where do we get 5C in the? Okay. But there is a spell, please see, you have the death certificate filed by you, it's the same person. At page 10, you filed the death certificate of D5C. Is he the same person? Starting with K. How do we know? Who establishes all this? What is the genuineness of your application? Then get a succession certificate. We can't go into all this.
Why? Why? No. Why a legal representative won't get a succession certificate? No. You filed what brother said is that you filed an application along with a succession certificate, then perhaps we would be in a position to decide. Well, you said I can't get a succession certificate. We are asking you what prevents in law from this thing getting a succession certificate from the competent court. If there is no objection, you will get it on 31st day. It will be published. Nobody objects. You get the succession certificate. No. You know the nature of litigation, madam. No, in this. No, nobody is appearing in your case. Notice has been issued despite that they are absent. No, notice of this application. Notice of this
Madam, let there be an inquiry at least from the MRO. See, because the certificates filed by you are looks to be different. You only filed a death certificate and a Aadhaar card. That's all. On that basis, how can this court recognize you as the legal head? There must be some proceedings to that effect. No. Madam, during the pendency of the suit, yes, you have a case, but we have gone ahead. This is only at the stage of drawing the final decree. From the stage of compromise, now you have to give a proper identification of the parties who are there in the compromise decree. In the absence of that, simple applications we cannot entertain, or at least it should be supported by some proceedings. Nothing is there, then anybody can come on record. Where is the end to this? Take proper instructions. Otherwise, we'll dismiss that tribunal. It's not clear.
That is is to directly present the final succession certificate. Then we will.
Or at least file an application before the lower court and get a succession certificate. We will not dismiss till then.
File a succession certificate, then we decide.
Everybody has.
It will be uncontrollable, madam. 1958, another 50 years, it never won't be decided if we allow your application. No, succession certificate. There is no opposition in any case. You are well known in the family. So you will file an application. As we said, on 31st day, there will be nobody will file an objection to you because you are known member of the family. They will grant you succession certificate. What happens? Succession certificate is the proceeding is taken when a claim is contested. You are saying that nobody is opposing my claim. So nobody will oppose your claim. You will get the succession certificate. No. We don't know. So file succession certificate.
Case.
Yes, madam. Get a proper succession certificate. This application per se is not complete to bring the LRs on record.
Yes. Learned counsel for the in view of aforesaid order dated 3rd of January 23, advised. If any, shall continue. Interim order, if any. We don't know which interim order. Which, when date of interim order? When that, not tagged, madam, like this papers will, Mr. See how this
2000.
loose sheets. Which order? All right. Interim order, if any, shall continue. Yeah. You good.
Lordship, in this case, to file objections to the receiver report.
You are appearing for?
On behalf of NM petitioner. On petitioner.
Objection to commissioner's report.
Respondent.
What objections to what?
Filed by the.
He is not saying so. Objection only. What objection to what?
So, receiver.
Receiver?
Report of receiver.
Ask him. No, we have understood objection to, we are only asking to what? Objections to what you want to watch?
Is it for the report of the commissioner?
Report
7.
Reports.
So say so. Council, you also want to file? Well, you are appearing for respondent, Mr.
Respondent.
Learned counsel for respondent, praise fund is granted 4 weeks time to enable him to file objection to the report, which report of the commissioner appointed by this court.
May I please?
What does an office note? What is office note?
I was directed to file the copies of the plaint and a preliminary degree.
Copy of, you have to file copy of the plaint.
Plaint as well as preliminary degree. I file it. But then again, I was directed to file a fair copy. Well, I filed it along with USR number 50380 of 23.
You say that you have complied with the office object. Learned counsel for the applicant submits that he has complied with office objections on
on 14/6/2023.
14/6/2023. Office to proceed further.
Coming up for counter of the comment, stay is already granted in this.
You appear for whom? Mr. Learned counsel for learned GP revenue. Praise warrant is granted. 4 weeks time to enable him to file. 1 minute, one. Yes, Mr. All this, your action has been taken note of by division bench on 13th of March 23. You have developed 44 colonies and have regularized the allotment on this thing at the concessional rate of ₹250. What is this? Can it be done?
I'm sorry, my lord, in this case, my lord.
You don't know. You are not GP revenue, right? See, Mr. 3 weeks. Interim order granted on earlier occasion shall continue. Time for next. Alright. How many cases in arbitration at that bench? Single bench? Yes, Mr.
That it is four set of application filed by the
Huh?
petitioner. Four set of application filed by the petitioners.
What is this thing?
To implement, to recognize the same deed and to pass a final degree on paper publication.
Not sure.
The
No number.
number is not.
We are asking it. Yes. So what is some order passed in SLP?
The already the receiver commissioner is already appointed by this court.
Huh?
The await of the receiver report, my lord, the
report has been submitted now. Acha 14. Acha, we will
14.
await the report.
Yes.
Huh?
Awaiting for report, my lord.
Await the report of the commissioner. So Mr. This, yes. Tell him.
See, earlier, Mr. M.A. Bari has filed a report.
Yes. That is
Application is filed for now.
that is scheme of partition.
Now a new set of receivers have been appointed. So after filing their report, you can file application. This need not be heard. Nothing remains in this because we have appointed another set of.
Yes.
In view of, all right, so in view of order of this court by appointing a new set of court commissioners, new receivers come court commissioners, no order in this application need be passed at this point of time. Accordingly, the same is disposed of with the liberty to the petitioner to file an application after the report submitted by new so and so is filed. Accordingly, application is disposed of. So this all goes 119 for the reports. No other this 115. Let 100 call 150. This is for business. Yes. So call 150. You have seen, right? Parties. Huh? So that's what you have seen, right? That's why that part need not be. That's what we told you. That only in probably one case Geo was not challenged, he stopped leaves. Wherever Geo is challenged, you have deleted that sentence, right? Month 40. List after 4 weeks.
Lord, I am to inform that the petitioner council has given NOC wakalat, no objection to the petitioner. I'm also informed that we have taken out notice to them, Lord, fresh notice from the court may be ordered to the petitioner.
Why?
Lord, because
If you are pleading, it's not the duty of the court to, he has engaged the counsel, you have sent him a notice, we will say no instructions. Item 116, right?
Yes, madam.
Mr. So-and-so states that he has no instructions to prosecute the application on behalf of the applicant, therefore the same is dismissed for want of prosecution. Let him file restoration. You have done your duty. Hmm. Yes. None for the petitioner. Let the application be listed for this under the caption dismissal on the next date of hearing. After 1 week. Same order. After 1 week.
Wait, report after report.
All right, learned senior counsel for the applicant, report of the commissioner appointed by so and so is awaited. List after maybe 4 weeks. 4 weeks. Hundred.
120.
None appear.
120,
What?
Time for the response.
It's been deadlines Friday, next Friday.
Next Friday.
Krishna is absent.
All right. Mr. So and so prays for accommodation on the ground that arguing counsel is unwell. List next Friday.
Sorry for the inconvenience. Apologize for the inconvenience.
I've already filed the objections.
Yes. Next Friday. Mr. 121.
121 and 122, they can dismiss as infractious.
Acha, 121 and 122.
Dismissed as infractious.
Shall we record your
Yes.
learned senior counsel submits that the relief claimed in the application has been rendered infructuous on account of efflux of time. The aforesaid submission is placed on record. Accordingly, the application is dismissed as infructuous. 121, 122. Next. These
One 23 and 125 will go together.
Yes, please.
123 and 125 will go together. It can start over by 2 weeks.
123
and 125.
So like arguing counsel 123, 125, it is submitted that arguing counsel is unwell. List after 2 weeks. 124.
Would require a hearing.
Report of the commissioner is necessary for adjudication of this issue matters.
Shall we await? Shall we await the report of the commissioner?
This is
What-
not, I think, it's beyond this.
124.
This is regarding registration.
Yes, matters. And subject matter pertains to Hafiz Beg, survey number 78 minutes. My lords were pleased to appoint Muhammad Nizamuddin, a retired judicial officer, as a.
No, the only thing is when senior counsel says that report is not necessary.
Not necessary in this case.
Necessary matters. My submission is minutes. Subject property pertains to CS 14.
No, subject property, there's no.
Hafiz Beg is part and parcel of CS 14 minutes. Report of the receiver is necessary for adjudication of this issue matters.
You file counter.
Let him file counter, so that will make it.
Learned counsel for whatever revenue.
Minutes. Item 124 minutes, readings are completed minutes.
2 weeks time to enable him to file counter.
Already they have filed counter affidavit long back.
He has filed.
Just already see the model. Leave it. Let us have it after.
Request petition also filed.
Mark the presence.
I'm instructed in interim order is already.
List after 4 weeks, interim order granted on earlier occasion shall continue till next date. Yeah, 125 adjourned, Mr. Already. 123, 1.
This is also pertains to Hafiz Pet, my lords. Report of the commissioner is necessary, my lords.
None for the petitioner. Hearing deferred list after what, 4 weeks?
Prayer.
It's Friday, I'll come. Friday. Yes, my lord, Friday. I'm for the response.
Mark presence list on what Friday? Next,
Any Friday.
11th August.
Lordships may kindly permit me to withdraw this instruction.
Seeks leave of this court to Mr. So and so learned counsel for the petitioner seeks leave of this court to withdraw the writ petition. He is permitted to do so. Accordingly, writ petition is dismissed as withdrawn. Good.
My lords, it's a court matter, my lord. It is for the registration, my lords.
Report of the commissioner is necessary, my lords.
My lord,
As on today, there is no final decree, my lords.
my lord, it's already registered. There is a sale that existed. This is in a 15th floor, one plot registration. They stopped, my lord. It is in a 15th floor, one plot, my lords. It's already registered. I'm reselling. Yes, my lord. Plot. In 15th floor.
Not plot. We were just wondering how can there be a plot on 15th floor?
FLAT, my lords. FLAT plot apartment, my lords.
Apart.
It's already registered. Sale deeds are existed. It's a reselling of the apartments, my lord.
Then what's your problem, sir? Registered, sold.
It's a government property, my lords. It's in prohibitory, put it to a prohibitory list, my lords.
No, flat belongs to state government.
No, land belongs to state government.
So.
Hillspate is part of CS.
Yes, ma'am.
Don't
Number
Mr.
76 to 80, my lords.
And this property is situated in an area which is subject matter of civil suit number
CS 14 of 1958.
14 of 1958.
Yes.
Full stop in view of aforesaid hearing is deferred list after 4 weeks.
My lords, interim relief, my lords, there is already sale deeds are existed, my lord. I'm actually.
Nobody is challenging your sale deed, right? There.
My lord, in 2019 also it is transferred, my lord. That time they are allowed. When I'm purchasing, then only they are restricting, my lord. It is a second-hand apartment, my lords. There is a hundreds of plots in the same survey number they have registered.
We don't want you to be a party in OS 14 of 58, right? Why do you want to be free of litigation and hope that a final decree in OS 7 is passed and be happy thereafter?
My lords, if any condition can be given, my lord, it's already.
Sale deed has already been registered.
For other matters or other apartments, what is the order is there, it can be covered with the same conditions, my lord.
Which order?
It's in page number 28, my lords. This is already allowed by the single bench, my lord.
Have you suffered order?
4115, my lords, there is an order, my lords.
Then?
My lords, once,
how can you then?
after that, my lords, subsequent development is, my lords.
No, he is like, he is bound by doctrine of lis pendens.
There is a
Yes, my lord.
my lords, in this
Yes,
year,
my
my lords,
Bound by doctrine of lis pendens.
CS 14, my lords, there is a judicial order, my lords, not to alienate the subject property.
We are also passing judicial order. Not,
Your lordships are also.
not no, any other order.
Your lordships, my
Mister,
lords.
please understand,
My lords.
if the direction, understand, you should not take time. If a direction issued by learned single judge in a writ petition in respect of a similarly situated person has been implemented by you, is the justification for this thing. Taking a different view, you are the state, right? You may be, why did you not say in that petition? And have you?
Subsequent development is, my lords, are pleased to appoint a receiver and
Have
commissioner,
you,
my lords.
Mr. We want straight answer.
Yes, my lords.
He is relying on a judgment pass in case of a similarly situated person.
My lords.
Is it so? And second is, have you implemented this? Then we will examine.
I will get instructions to the my lords.
Which order, Mr.?
My lord,
Yes,
page number 28, my lord.
page 129, item 129.
No, my lord. In the.
Item, Mr. Which case?
Yes, my lords. Yes, my lords. 129.
129. Write down. So and so learned counsel for the petitioner submits that that a similarly situated person had filed a writ petition. Similarly situated person like the petitioner had filed WP number
25294 of 2022.
In which an order was passed in favor of the petitioner. He therefore seeks parity in treatment. However, learned so and so additional government and whatever submits seeks prays for adjournment to enable him to ascertain whether directions issued by learned single judge in so and so have been implemented by the government. Government list after 2 weeks. 2 weeks.
130 needed time, my lord. It's my colleague matter.
130. You need time.
2 weeks, my lord.
Learned petitioner prays for adjournment list after 2 weeks. 131.
Item 131, 132, I am appearing in.
Oh.
I kindly take up 132 first.
What is
it?
it?
Petitioners are same in both the writ petitions. 132.
What is it?
Well, this writ petition is filed questioning the order of RDO. Well, when rejecting the appeal, saying that he is not the authority to decide the appeal under Land Encroachment Act. Initially, appeal was filed.
What is RDO?
Well, Revenue Divisional Officer.
Due to the abbreviations here, that's why.
A Revenue Divisional Officer is the third respondent. Well, order is passed by the Tahsildar, fourth respondent, under Section 7 of Land Encroachment Act. Well, that was challenged initially before the district collector. Then district collector said, I am not the authority, go before the RDO. Then I went before the RDO. Now RDO passes this impugned endorsement saying that I am not the authority.
Wait, which order?
Well, that order you will actually find
dated.
Original 2/8/2020. 2nd August 2022 is the endorsement which is impugned to this rate.
So, which provision provides for appeal? Section 10. Give Land Encroachment Act. Section 10, what does it say? Read, Mr.
An appeal shall lie to the collector from any
collector.
Then collector is defined. That's what. 1A. Definition is section 1 capital A. A. Collector means any officer in charge of a revenue division and includes a deputy collector, a sub collector, and an assistant collector.
Mr. What is?
I'll file my counter.
What counter? You are not even deciding, discharging your statutory functions. How does it matter whether collector decides or any additional or RDO decides or whosoever decides? But the fact remains, statute confers a right of appeal on him. It has to be dealt with. What counter?
In this case, that's
counter you will file that we will not decide.
Report
the
of
appeal.
Report of the commissioner.
Nothing.
Asmatpet is also part of CS.
He has to. This is a matter pertaining to Encroachment Act.
Subject property pertains to CS 14 Asmatpet. Kindly see page 23, my lord. District, I went before the district.
I admit, Mr. that it part of CS 14.
That's why the matters are listed before your lordships. Because the property they are claiming under the preliminary decree. And there was a.
Who has encroached your property?
No, they say that I am encroacher. Government is claiming it is their land. So they have initiated proceedings under Land Encroachment Act. So only limited thing is whether I am encroacher or not is to be seen by the competent authority.
There is an order of stay here.
No, there is no interim order in this case is concerned.
So then,
no,
they have not taken any action for your this thing removal.
Because there is no order in first petition. Now the MRO Tahsildar has addressed the letter to the SHO police to give police protection to evictors.
And there is a stay.
No, both the petitions are listed before lordships today. And I'm taking time for counter, and now there is a threat of dispossession. Well, my title.
All right, we will grant you time, then maintain the status quo. Don't do this thing. We will say.
My lordship, humble submission, my lordship.
Honorable Supreme Court
has passed an order, my lordship. Honorable Supreme Court has passed an order in regards to the preliminary degree claims. So anything claimed through the preliminary degree is invalid. Yes, my lord. These are the orders which has been passed.
While adjudicating the issue pertains to Hydernagar, my lord.
Hydernagar.
So Honorable Supreme Court, my lords,
No, Mr.
Let us not confuse the thing. It is restored to Hyder Nagar. I appeared in that matter.
Even I have.
With respect to Hyder Nagar. Anyway, they place it before your lordship, my lord, which is related to this. Definitely, I am able to answer it. The question is now, limited question is, you have initiated proceedings against me under Land Encroachment Act. When I go before the collector, collector says go before the RTO. In fact, RTO is the authority. When I go before RTO, he says that I will not entertain it. That I am, that's all. The other things cannot be
How
limited
can
in
you,
this case.
Mr. This, you seek time to file counter, right? And you want to take action against him all, what is this?
They have no right in matters, it's a government land matters.
The government land
They are
means.
third party here, they are saying government, zero matter degree.
Not
Third party.
May not be government land.
Absolutely not.
No, but even an encroacher has to be removed in accordance with law. Assuming for a moment he is an encroacher, he has a right to file an appeal under section 10. What is this? I mean, he should have come forward saying that we will decide his appeal in a time bound manner, 30 days, understandable. The government advocate is seeking time to file counter. What option do we have?
All these litigations will end once the final dealings are paid first.
These people are 31 parties, and I don't know.
Are you having final decree as on date, Mr. Alex? Are you having final decree to this property as on date?
Not as post, I mean, it's right for recognized and person was given through civil court as per the orders of Sanam Court. That whatever the court is concerned, where rights were recognized, paybacks, and then possession was given through civil court. They are not under challenge. Now they want to take advantage of latest judgment of Supreme Court dealing with the Hyder Nagar. You cannot mix up. But 1963 there was a government was a party. Multiple times, 5 or 6 government went up to Supreme Court. Now, suddenly, taking some observations in the latest judgment of the Supreme Court dealing with Asmat Pay, and everybody is trying to wrote in and say that the government that.
How many people like you are there in this? We are wondering whether there is a long queue of litigants.
Submission, my lordship, humble submission.
Lighter vein, lighter vein. So people waiting, watching. This. Like, so 1,000 petitions, right? If we enter to lakhs.
Oh. Maybe lakhs now.
My lordship, the assignments claims were settled.
Mr. We are not formally issuing notice, but you give an undertaking that till you, for next week, till you file counter, you will not dispossess him, that's all. And no, because, undertaking not. So then how, then what do you say with regard to, just a minute then, please tell us, how do you meet the submission? Like, he has made out a case, his grievances, you have understood, we need not repeat. And how pending adjudication of his right in the writ petition? Rather, there is no right. He is only in possession. His title he has yet to. But even if he is unauthorized person, he has to be, we have held that procedure under this AP Act, Land Encroachment Act, has to be followed by relying on 68 Supreme Court 620. Then you should have simply said that we will decide his appeal within 3 weeks. And that's the end of the matter. You are filing, you are praying for time to file counter. Right? Correct? And you want him to be thrown out, police officer, saying that the land belongs to the government. It's not permissible. There is an order against him, but he has a right to file an appeal. That appeal has to be this thing decided. You can't like.
The production was thrown by the honorable court. Kindly see page 37 of the order. In the same very appeal, it was disclosed of directing the parties to make
Right, what to do? How much time? That means you are inviting trouble for yourself and this thing. We can already see a long queue. What, mister? No, do it within 1 week. Next Friday we will. No. There is already an order.
Yes, while appeal was pending, there was an order.
Who according to you is the competent person? We'll record your submission and we'll direct that his appeal will be decided. What, like section, you will repeal section 10 by the next date, right? Huh? Their government could do anything. Assembly session is going on, right? Huh? Tomorrow they will bring an amendment repealing section 10.
Normally, revenue divisional officer.
Lighter vein.
I understood that, my lord. Normally, what happens if collector says RDO is the authority?
You don't, this thing, get it right. What to do, mister?
Have you filed counter in this writ petition? 12262 of 2000, same issue, page 46.
They don't file counter in any case, and I had to file 4 writ petitions, and 1 writ petition was this one. My lord decided that admission
Case, right? Not of petition. Yes. Mark the presence. Everybody's presence. Learned senior.
I have no issue.
No issue, right.
Both of them will pass orders in your.
So you say, learned government advocate submits that the appeal preferred, that in case petitioner prefers an appeal before the collector.
Statute confers powers and revenue division office. We can confer jurisdiction on collector. Tomorrow there will be a technical issue. You will have to make under 226 may direct. But tomorrow they will say statutory appeal lies to the revenue division officer for the section. Then
So what do you say, Mr. Right? Learned counsel for learned whatever GP for revenue submits that an appeal lies against the order passed by the Tehsildar under section 10 of the Act to Revenue Divisional Officer, paragraph. We have considered the rival submission made on both sides. Section Mr. We know that it's best thing not to take a stand, and at times not taking a stand amounts to taking a stand. But this is a case where you have to say you can't defend both the orders. That's why we asked you sort of urge you to take a stand. Otherwise, we would have granted you time to file counter. We don't want to keep it pending. Both the petitions, right? Same orders, like.
My lord, item number 133 to 146 I appear, my lord.
Yes.
Bearing two caps, my lord, one on the cap of the petitioner and the other the cap of the respondent.
Shall we hear you next Friday?
My lord, the Friday after that. If
All
the
right.
lord is so kind.
On account of paucity of time, that's why.
There is one more.
133 to 146, on account of paucity of time, the matters could not be taken up. The list week after next.
148 also, up to 148.
Up to 148, right?
My lord, can I make I impose upon my lord, one day a week may not be sufficient for a hearing of this magnitude.
Yes.
So maybe
We
one
will.
week, my lord, if your lordship. Because 1 week out, where your lordship may hear this matter from 2:30 on that week, my lord. We will keep ourselves in Hyderabad to argue it.
Yes. Yes,
Maybe your
correct.
lordship can
Yes, we'll consider.
please
Definitely.
consider that, my lord.
Yes.
So if I argue also on a Friday, again
Yeah.
recommence the argument on the next Friday,
Yes.
it will be all lost, man.
Yes, yes, correct. We'll consider.
Please consider.
Yes.
I'm grateful.
Thank you. Yes. So remaining cases, whatever.
My lord, there is one more thing, my lord. OSA 54 of 2023, it's not in the list, my lord. OSA 54 of 2023 was decided by a division bench of this court, setting aside as fraudulent a final degree of this court. That went up to the Supreme Court. It was affirmed by the Supreme Court by the recent judgment. Now there is a review petition pending at its manner. Review IA number 4 of 21.
No, review petition pending before
There is a review petition, my lord,
Supreme Court.
which has been, no, in this court, which has been mentioned in the last paragraph of the Supreme Court judgment.
So what is the legal position, even if
It is, my lord, that if all the final degrees in CS 14 are set out,
no, but
then
it's not there, right? We need not advert to.
we need not use it
Today.
But I have a different, my argument then will change, man.
All right. We'll hear you on the next date. Right now, you will appreciate I have to sit in a different combination. Like we would have loved to hear you, but unfortunately no time. We'll see. Need some more time.
Yes.
This bench, definitely your suggestion is good, but
I
you know.
understand.
my lord.
I understand, my lord. Pressure on your judiciary.
My lordship, a humble submission.
Yes.
My lordship, a humble submission. My lordship, we wanted to forward for an order of the Supreme Court recently passed by the Supreme Court to the receiver cum commissioners in CS 14. So we wanted to pass this order to the receiver.
No, place it on record, Mr. What is this practice of passing on? Place it on by a memo, right?
Yes,
Let it be a part of the record.
Yes, ma'am, I'll do.
Who will? What? Next week. Next week. Remaining cases next week. We'll be. I'll be assembling. Yes. First time notice.
Let's have to mention them. I have to mention.
What mentioned, Mr. At the end of the list? It's not in the list. Wait. So right. So then 165 to 188, who is there? Only those cases the councils are there, we can pass an order.
66 members.
So
166.
you say, madam, in remaining cases, whatever is taken up, I will pass an order. Remaining say, on account of paucity of time, matter could not be taken up, give a date next week. What Friday? 11th August. So which now all cases, the order will be same. He is at which case, Mr.?
166 members.
What do you say?
This is an application filed under section 11. It is an application.
We know that. Arbitration agreement there, not there.
Appointment of arbitrator, respondent has to file counter in this.
Madam?
Yeah.
She is not appearing. So it goes to next week. All cases.
Item 176, my lord, I am for the petitioner. My friend is appearing for respondent. My lord, may have it next week, my lord.
So every case like.
So grateful.
So great. Which case, madam?
177, your lordship.
Yes, what do you want? You want to withdraw?
And for the applicant, your lordship, counter has been filed and it was served yesterday, your lordship. Request for 2 weeks of time, your lordship.
177, praise warrant is granted. 2 weeks time to enable her to go through the counter and to file a rejoinder if so advised.
Matter, my lords, item 171, my lords. In this matter, my lords, the notice has been issued but retained as unclaimed. So seeking for an appointment of arbitrator in this matter, my lords.
Next week, goes to next week, madam. Friday, 11th August.
Obliged, my lords.
No, the problem is even though they are not served, they may raise an objection that we were watching the proceeding till 4:30. It's not taken up.
My lords, even in the notice that we have sent, arbitration notice, it was returned as unclaimed. So
Fine.
obliged.
An order is required to be passed, you will appreciate.
Indeed, obliged.
Yes.
It is directed to be listed today, my lord.
No, just a minute, up to 188 over, nobody is present. So they say, madam, common order, next Friday, 11/8, fine. And now which out of mention, what out of list?
Not in the list, my lord. Notice is served and proof of service is filed.
11th August. On next Friday, that's the earliest possible thing.
My lords, I apologize. It was 179 item number, my lords. It was not 171. I
Big
apologize.
actions, madam, we rely on you.
I apologize.
Wrong order would have been passed.
I apologize for this.
That's why it's safer to have everything at next Friday. So as it is, it goes without even mention, everything goes to next Friday.
Obligement.
Let's bill permission. It's arbitration application number 70 of 2023.
Fresh matter you have filed.
Its notice was issued on the 17th of April for 23rd of June.
Served.
On 23rd of.
Served
Yes,
or not?
yes, man, sir.
Served. Next Friday.
Alex, may I request for 25th of this month, Manoj? That's a Friday also.
Friday only.
25th, sir.
Madam, Mr. 25th August is a Friday. Holiday. Something red. This thing. Karnataka. This is this thing. Friday is a holiday.
Alex, then I may request for 1st of September, Manoj. It's a Friday.
1st September. That you could have done. You are an outstation council.
I am an outstation.
He could have done, right?
Manoj thinking that today the matter will be set up. Not
So, what to do? We will find out why it is not listed. You give that number, we'll find out why it is not listed. So, 1st September.
First.
Anything else? That's it. Friday. Everything goes to Friday. Otherwise, we would have called and then said none and Friday instead of it. Right? Friday.